May we have the announcement? May we have the announcements, please?
Before we begin the agenda, the Wichita-Sedgwick County Metropolitan Area Planning Commission and the Wichita-Sedgwick County Board of Zoning Appeals would like to take this opportunity to welcome everyone to this public hearing. Copies of the agenda for today's meeting, the public hearing procedure, and Planning Department staff reports on all agenda items are available in the lobby of this conference room. The Planning Commission's and the BZA's bylaws limit the applicant on a zoning, subdivision, or variance application and his or her representative to a total of 10 minutes of speaking time at the start of the hearing on that item, plus up to 2 minutes at the conclusion of that hearing. All other persons wishing to speak on agenda items are limited to 3 minutes per person. However, if they feel that it is needed and justified, the chairman may extend these times by up to 2 minutes. All speakers are requested to state his or her name and address for the record when beginning to speak. When you are finished speaking, please write your name, address, and the case number on the sheet provided in the lobby. This will enable staff to notify you if there are any additional proceedings concerning that item. Please note that all written and visual materials you present to the Commission and the Board will be retained by the Secretary as part of the official record. If you are not speaking but you wish to be notified about future proceedings on a particular case, please sign in on that same sheet. The Planning Commission and the Board are interested in hearing the views of all persons who wish to express themselves on the agenda items. However, we ask that all speakers please be as concise as possible and avoid long repetitions of facts or opinions which have already been stated. For your information, the Wichita City Council has adopted a policy for all city zoning items. A copy of this policy is available in the lobby. The City Council relies on a written record of the Planning Commission hearings and does not conduct its own additional public hearings on these items. The decision of the BZA is final. Any appeal of a decision of the BZA is to district court.
Okay, we have a quorum. Let's look at the agenda of the Planning Commission first. Item 2-1, which is a 00019, one-step final plat for Sienna Lakes, second edition. Anyone in the commission wish to hear that? Anyone in the audience wishing to hear that item? We'll take it by consent. 2-2, which is a one-step final plat for Chica's Edition, located south of East MacArthur Road and east side of South Hydraulic Avenue. Anybody on the commission wish to hear that item? Anyone in the audience wish to hear the item? Okay, we'll take it by consent. Item 2-3, a one-step final plat for Home Base Edition. Anybody on the commission wishing to hear that item? Anyone in the audience wishing to hear the item? Okay, we'll take it by consent. Do we have a motion?
So moved.
Second.
A move by Mr. Green, second by Rob. Any discussion? Seeing none, all in favor?
Aye.
Opposed? Okay. Now we'll go to the vacation items. 00014, city vacation of a platted utility easement. Anyone in the commission wishing to hear that item? Anyone in the audience wish to hear that item? Okay, we'll take it by consent. 3.2, 00016, city vacation of platted drainage and utility easements. Anybody on the commission wishing to hear that item? Anyone in the audience? Okay, we'll take it by consent. 3-3, 00017, city vacation of 30-foot platted setback to zero setback on an LC limited commercial zone lot. Anyone in the commission wishing to hear that item? Mr. Blick will hear that item. So we have a motion on 3-1, 3-2.
Move to approve. Second.
Mr. Green, Rob, okay. Anybody Any discussion? Seeing none, all in favor?
Aye.
Opposed? Okay. All right, we'll go to the public hearings. The first one is number 4, which is 00028, a city conditional use to permit an accessory dwelling unit on property zone TF3, two-family residential. Anybody on the commission wishing to hear that item?
Chairman, I had a staff question on that item.
Okay, let's just hear that real quick. The staff come up and we'll ask that question. Mr. Foster?
Kathy, on page 2, where it references public services, there's a reference to Wetmore Street intersects with South Mays Road at 2 locations. Mays Road is 4-lane. Is that the correct reference for the street?
No, that is not, because this is located on South Ida between OC and Funston. That's a typographical error in the staff report.
And the second question is, if you could, on their diagram, there's a note about it's 12 feet from the alley to the new addition.
Yes.
Is there any setback concern there that?
No,
that he needs
that
to-
is typical. You go from the center of the alley line, and you can basically it puts you within 5 feet of your rear property line. That is typical and appropriate for that type of a structure in that location.
Thank you.
Okay, does that satisfy you? Mr. Green?
Yeah, Mr. Chairman, my concern also was the Wetmore and Mays Road references, so.
So then we have no need to hear it from a commission standpoint, right? Anybody in the audience wish to hear that item? Seeing none, we'll take that by consent. Item 5, which is case number 00029, a city conditional use to allow an indoor collection, processing, storage, and shipping of aerospace waste materials. Anybody in the commission wishing to hear that item? Anyone in the audience wishing to hear that item? If you do, raise your hand high so I can see it. Okay, we'll take that by consent. Item number 6, 00030.
Mr. Chairman,
Yes,
I got to abstain from this item.
okay. City conditional use for indoor wrecking salvage associated with BZA 2018-00047 on property zone limited industrial. Anybody in the commission wishing to hear that item? Anybody in the audience that desires to hear this item? Okay, we'll take that by consent. Can we get him back? Come back, Bill. Item number 7, case number 2018-00023, a city zone change from GC, General Commercial, to CBD, Central Business District. Anybody in the commission wishing to hear this item? Anyone in the audience desires to hear this item? Seeing none, we'll take it by consent. Okay, item number 8, zoning case 2018-00024, city zone change from single-family residential to two-family residential on approximately 9 acres. Anyone in the commission wishing to hear that item? Seeing none, anyone in the audience? We will hear that item. Item number 9 is a city zone change, 00025, from single-family residential to two-family residential. It's actually a combination of single-family residential and two-family residential to MF18, multifamily residential. Anybody in the commission wishing to hear that item? Okay, we'll hear that item. And then we have some non-public agenda items, and we won't, 10, I'm sorry. I guess I was trying to move too fast here. Zoning 2018-00026, a city zone change from single-family residential to two-family residential. Anyone in the commission wishing to hear item 10? Anyone in the audience wishing to hear item 10? Okay, let's,
Yes.
who?
You heard.
Oh, she's the applicant, okay.
So you don't care, I mean. So, so let's have a motion. Wait, no. Mr. Warren made the motion, Mr. Green seconded. Any discussion? All in favor? Aye. What is that? 10-0? 11-0?
Move to,
Okay.
yeah, move to approve item number 6.
Second.
Bob, you second that?
Yes.
And Mr. Warren made the motion. Any discussion? Seeing none, all in favor?
Aye.
Opposed? Abstain. So it's 10-0-1. Okay, let's turn now to the agenda for the Board of Zoning Appeals. Item 1 is the BZA 2018-00040, a city appeal of administrative interpretation classifying a voluntary substance abuse facility as a group residence. Anyone in the commission wishing to hear that item? So we'll hear that item. Item number 2, BZA 2018-00045, city variance for a temporary gravel parking area for a pop-up park in downtown on property zone CBD, commercial business, central business district. Anyone wishing to hear that item? Anyone in the audience wishing to hear that item? Jason, you want to talk about that? Oh. We'll take that by consent. All right, item number 3, 2018-00047, city variance to reduce the front setback from 20 feet to 0 feet to construct a building for an indoor wrecking, salvage, and this is related to, we can't really take that one until after we do 2018-003.
Which you, it's been approved.
We can take it, can't we?
Mr. Chairman, I got to abstain from
Okay.
that.
Anybody on the commission wishing to hear this item? Anyone in the audience wishing to hear the item? Okay, we'll take it by consent.
We approve items 2 and 3 on the BZA agenda.
Second.
Let me back up. Now that we have this information, I'd like to call the meeting of the Board of Zoning Appeals to order. We have a motion on 2 and 3.
We'll move.
Second.
Okay. Mr. Green made the motion. Yes. Yes, we
Item
should.
number 2, I move that we approve.
Second. Second.
Second.
Made the second. Rob, oh, Mr. Klaus, let's give Mr. Klausmeyer a chance. Any discussion? Seeing none, all in favor?
Aye.
Opposed? Okay, so that's 11-0. Yeah. Okay, item number 3.
Move to approve.
Second. Mr. Florence seconded. Mr. Green made the motion. Oh, Mr. Warren made the motion. It's hard to look down here and up there. Any discussion? Seeing none, all in favor?
Aye.
Opposed? Abstain. So it's 10-0-1. So we'll hear item 1. And how many in the audience are here to hear item number 1 on the Board of Zoning Appeal? Okay, how many are here to hear items on the Planning Commission agenda? Like a toss-up. So we'll flip a coin. You call it, Dale.
Call it Dale.
Heads for the planning commission? Tails. So we'll do the Board of Zoning Appeals first. And we're already in session, so we'll continue in session. And let me see, who's presenting that? Oh, Dale's gonna. Thank you, Dale. About that.
Jim, can you get me to the BZA slides or somebody?
I can.
Thank you. Dale Miller, Plain staff. BZA members, this is a little unusual in that it's been quite a while since you've heard an appeal, but appeals are provided for by the zoning code in the sense that if there is an interpretation of what the code says, or it's not clearly evident what the code says, parties are able to ask the zoning administrator to make a decision about what the code means. And in this case, what we have on the property that is referenced with the arrow and the blue outline is we have an addiction treatment facility that is in place, and we have third parties, meaning they are not the property owner, asking the zoning administrator whether this is a legal use on this site. And so what you are asked to do today is to basically act like a judge or a jury, hear the evidence, and then decide whether the opinion of the zoning administrator was correct or whether the appeal by the applicants is correct. And so the order in which we'll take this is staff will give the presentation first, and then the applicant, which is not the property owner, they will go second, and then we'll have the agent for the property owner go third, and then hear any other comments from the public for or against the situation, then let you decide what to do. But that's essentially what you're being asked here, is to hear the evidence and determine whether the zoning administrator properly interpreted the code in making the decision about this particular use. And as you can see here, the property is zoned limited commercial. It is in a community unit plan. As best staff can tell, the community unit plan was established back in 1970. This is on parcel 30. And parcel 30, as far as we can tell, has remained unchanged since 1970. As you can see here, it is located north of Kellogg off of Holland Lane. And when we get to the aerial, Woodchuck's over here, the university is to the north. This is, I believe this is the first meeting where we've had the latest aerials available. And so we believe this is a reasonably accurate photo of the area, but it is, after having been out there, it is somewhat isolated in that it is developed here, but there's nothing to the north. This is the old Harley-Davidson motorcycle sales shop, some other uses that front Kellogg, and then you have single-family homes to the west, undeveloped property to the north that the property is part of the community unit plan as well. There are offices over here to the northeast, and then this is vacant ground except for this parking area that you can see that I'm not sure who it serves, but it looks like at one time there must have been a building there, given the way the parking lot is shaped, a hotel, but it's gone now, so. Okay, and apparently recently it was rezoned for a U-Haul facility. This is a close-up of the facility as it exists on the property. And here's the community unit plan. It is a fairly large community unit plan that goes all the way over to Ridge Road and up to University Avenue and over to Woodchuck and then back down and around. And then this is the parcel that we're dealing with is part of parcel 30. It's the south half of parcel 30. And here are the uses that the community unit plan allows in parcel 30. There are commercial uses, a motor hotel, mobile home sales subject to BZA approval, which because of the age of the CUP now would be a CUP and amendment, as well as the automotive agency, which on the CUP it says BZA approval, but would be an amendment to the CUP. The critical ones for the purposes of our discussion in my mind are the commercial uses, the motor hotel, and the mobile home sales are the permitted uses on the site without additional approval. This is looking at the facility. It's kind of the north series of buildings. Over here is to the north. We're looking west from the site of that old hotel. This is the closest office building to the northeast. Property line to property line, it's about 124 feet across Holland Lane. That's just a more close-up look. This is looking straight east across the property where the old hotel was to two more recent hotels. And then this is the old Harley-Davidson facility that's straight south. And then this is looking west from the facility across parcel 30 that's undeveloped to the backyards of the homes that are further west that front onto Woodchuck, I believe it is, or streets coming off of Woodchuck. There's some cul-de-sacs coming off. And then there was a gentleman who, I believe at your locations, there are some additional handouts. One gentleman lives immediately to the west in one of these houses here. He sent a series of photos, and so I told him I would show them. I'm not going to be able to narrate them, but I promised I would show them, so I'm showing you the photos of what he submitted, and you have his commentary there. And so,
Name is,
I'm sorry?
is it Marco?
Yes, Marco, and I've forgotten his last name. Yeah, for those in the audience, they will give you an opportunity to speak at the appropriate time. Yeah, then here's the other photos, and this, I believe, from his email, is the dirt pile that he was referring to. I assume that's why these photos are there. Back up to the back up to the aerial. To summarize the zoning administrator's position, as you know, because the zoning code lists particular uses, every time someone comes in and says, I want to do X, Y, or Z, if it's not a listed use, then staff has to figure out what listed use best fits what it is that they want to do. Well, in this case, the analysis that the zoning administrator went through was that this use is best categorized as a group residence. And so that's the bottom line of the zoning administrator's opinion, is that this is a group residence, partially based on a 2010 opinion made by a previous zoning administrator that this facility or this property, I don't know if it's the exact buildings, were previously used as an assisted living facility on this parcel. That assisted living facility has gone away, but that use went in on the basis of a zoning administrator's opinion that because the site allows a hotel, a motel, and all those commercial uses allowed by LC, that the assisted living facility was of a much less intense than what the parcel is allowed to have, and allowed that assisted living facility to be there. Well, in converting to the addiction facility, part of the zoning administrator's present ruling is that what they're doing now is not that substantially different from what a hotel or a motel would have, or what the assisted living facility allowed. And that was the basis for the decision. And I won't go into the whole detail because it's all in the staff report. But that's essentially the bottom line, is that this facility, as run, because there are no folks, as I understand, there are no folks there that are ordered by the courts or on probation to be there, is all voluntary. And so they're not a correctional placement residence, and that they are free to come and go. It's up to them, that it's similar to a group residence, which has a definition that includes staff members, that this is an appropriate use as zoned. So with that, I'll try and stop and answer questions.
Dale, we have another letter from Joe Verbeck-Mose talking about the Ridge Plaza Office Park. Can you show where that is?
That's this one here, where I had the close-up view of, yeah,
Okay,
that's to the northeast. It's the one that's about 124 feet property line to property line.
thank you. Any questions for staff? Okay, seeing none. The people making the appeal have the opportunity to speak at this time, and how much time they have, Dale?
Well, I assume we would treat them the same as an applicant and give them 10 minutes.
And then we're going to give the applicant 10 minutes?
Yes,
I mean,
the property owner.
property owner.
Yeah.
Okay, who is?
Mr. Kaplan is the agent.
Mr. Kaplan, you're speaking for the agent, right?
Take me 10 minutes just to get to the podium.
We won't count that time against you.
Yeah, don't start the clock.
Get ready.
Mr. Chairman, Commissioners, Bob Kaplan, 301 North Main Epic Center for the applicant. Let me clarify some things so that we're off on the right foot here, because I'm not sure that you really have the issue in mind, that what it is. We are not here to oppose this facility. We're not here to put them out of business. We are not here to suggest that we should not have drug abuse facilities in this area. What my clients are only interested in, here's what this is about. It's not that difficult. My clients are only interested in having an opportunity to air their views and their suggestions as to enhance the compatibility between this facility, Fieldview, and the neighboring residential area. Now, there is not one word in the zoning code in regard to a private drug abuse treatment facility. Nothing. It's totally silent. What happened when I got the call about this facility, I didn't know, because there's nothing in the code. The code deals with court-ordered facilities. People who have abused drugs have been arrested and are required to attend drug abuse by court order. That's in the code, And this is important, and that's a conditional use. This is a private facility, and staff has opined that a private facility can go anywhere in the county where the zoning is limited commercial. Nothing further, limited commercial. That's the issue. We do not see a distinction between court-ordered facility and private drug abuse facility. They do the same thing exactly. They're treatment facilities for people who have subjected themselves to drug abuse or to alcoholism. They provide exactly the same service. So why are we distinguishing between public and private? Now, the applicant has written a letter. Mike Lindenbach, you know him, I know him, has written a letter in which he believes that we're trying to shut down their facility. They didn't review the file. They did not review the file. I made it very explicitly clear to Mr. Miller, who certainly understands, that we are not asking that the facility be shut down or that anything be done with it. We would only ask that it be treated as the public facility is treated, so that they file an application for conditional use. We're not opposed to it. We simply want to have the folks who live in the neighborhood to the west have an opportunity to come up here and air their views and suggest conditions. That's all this is about. It really transcends. The important thing about this case is that it transcends this case. At the present time, currently, with the Planning Commission opinion, anyone that wants to put in a drug abuse facility can simply go anywhere in the county where there's limited commercial and put in a drug abuse facility. That's all that's required. Now, if a person is buying or leasing or building in a limited commercial district, they have no idea. They don't know. There's nothing in the code. So you build a house across the street from the 7-Eleven, and 6 months later, the 7-Eleven is a drug abusive facility. You have no way of knowing it. None at all. So what we need to do, the proper zoning for drug abuse treatment facilities, this should not be the subject of a debate. It ought not to be the subject of a debate. The code, the zoning code, ought to deal with it. That's why we have zoning codes. We have zoning codes to be sure that properties are compatible. And we have restrictions when we need to impose them to make sure that properties are compatible. Or we can oppose putting an incompatible property in a place where it ought to be. That's what the zoning code's all about. We're not using it. We're simply saying that this is a limited commercial. We have a comprehensive zoning code, which means everything has to be categorized someplace. And this facility needs to be addressed in the code. Admittedly, drug abuse today, I don't have to tell you, it's a major issue. It's an important issue and it has to be addressed. Treatment facilities are necessary. We don't say different, we've never said different. Facilities are necessary, but the answer is not simply to lump them into a limited commercial district. That's not the answer. The answer is to require a conditional use, just like we do on a public facility, and let the residents who live around the place come in and make their comments and air their views. That's all they're asking. You may or you may not accept them. We're not opposing the conditional use. We just want them to file one. And these neighbors can come in and they may say, I want this, I want that, I want security, I want fencing. whatever it is that they think ought to be imposed on the facility to make it compatible with their neighborhood. That's all they're asking. And that's the whole purpose, as I say, of the code. But there's nothing in the code right now. So it has to be corrected. And the way to correct it is to require a conditional use. It is not a group residence. It's not even close to the definition of a group residence. It's not a medical facility. State law, the statute, state statute 654602, Jeff, if you're interested, excludes drug treatment from medical services. There's a number of things you can do, but read the definition. I distributed the books. I don't know if you've had a chance to look at them. Perhaps not. I was going to get them out earlier and didn't. But it's not even close to the definition. The definition says that a group residence is a residential facility. This is not a residential facility. This is a treatment facility. This is a facility to treat people who have abused drugs and alcohol, and they need help, and that's fine. And we're in favor of that, and we're not opposed to it. But to just drop it in a neighborhood, the neighbors don't even know about it. How are they going to know about it? There's nothing in the code. They have no way of knowing. They build a house, and they find out that they're next to a drug house. They don't even know in advance it's going to happen, and they have nothing to say about it. And that's just simply not fair. That's just not fair. When I got the calls, I didn't know. Dale Miller and J.R. Cox and I talked about it. We traded phone calls, we traded email. I had good discourse with planning and with code enforcement, as I always do. And we discussed, where does this thing fit? And they finally came to the conclusion, and Dale advised me by letter, that it's a group residence. I said, Dale, no, it's not. And I appealed it. And that's why we're here today. So what we need to do is treat it as what it is, as a drug treatment facility, and treat it as we treat the public facility and require conditional use. So that's what I'm asking you to do. We get notice to the neighbors, we have a hearing, they can suggest security conditions or whatever they want. You may accept them, you may not. But we're not arguing that they should be shut down. We've never, ever said that. So that's the situation the way it is right now, and they can offer suggested conditions. I'm trying to save some time for my people. Are there any questions that I can answer?
Tell me again who you represent.
I'm representing Susan, your last name is, and Mike Eck. So now,
I'm confused.
yeah, I don't want to burn time.
So they're appealers? They're classified as appealers in this case?
Yeah, they're the applicants, Joe. That's true. They're the applicants. Now, there are a number of people.
But they're not the owner. They're the applicant.
No, they are not the owner. They are not the owner.
They're the ones that
And
filed the
they're
appeal.
simply, as Dale explained, they're simply third parties. They're simply third parties is all they are. That's right. I want them to have an opportunity to address.
Yeah, the zoning code allows for aggrieved parties to appeal interpretation of the zoning code. And one of the property owners, she lives just to the west here on Woodchuck and is within 300 and some feet. The other person who signed the appeal is about 18,000 feet away from here.
So has this gone to the DAB?
No, appeals do not go anywhere except here and then on to court if they are if the decision of the BZA is appealed.
Okay. So the neighborhood to the west has been notified?
Within 350 feet.
So isn't this the forum for them to come and complain? or to make suggestions?
Yes, they would be appealing the interpretation of the zoning administrator, the letter that was issued saying that this was a group residence.
So I don't understand, Mr. Kaplan, your contention is that if it had.
Let me,
That you'd have to file, just a second, that you'd have to file conditional use for them to get a voice. They have the voice today.
I don't think that they do as to the suggestion, because right now it's been defined as just being a group residence, and I think that it requires a conditional use. What I'm saying, Mr. Johnson, is that the zoning code has to include drug treatment facilities, and it has to include drug treatment facilities as a conditional use. This is more of a legal matter, and it does not. And that's what I'm espousing here, is that we require not just this case, not just Fieldview, but anyone wanting to put in a drug abuse facility obtain a conditional use. I think that's what's necessary.
I don't think any of us on the commission are attorneys either. You are? Oh.
But I was going to suggest that our legal counsel respond to this.
Okay, do you want to ask any questions to the appealer first?
No.
Okay, anybody else want to ask a question? Yes, Mr. Warren.
Mr. Kaplan, just, your contention then is that this is not a group home. From a definition standpoint, what do you see as the difference between a group home and a drug treatment
Well,
facility?
it's clearly not a group home, Mr. Warren.
I'm not sure I agree with that.
Yeah.
So give me the
they-
definition. What
Yeah,
you think
I
it is.
understand what you're
Yeah.
saying. No, I understand your question. They classified it as a group residence, but it's not a residential facility. It's a treatment facility. People go there to be treated for drug abuse. A residential facility, people go there to reside and to have meals and to be given a room and have a place to live. To say it's a residential facility, you go in the hospital for 30 days for serious surgery, and they say, well, you're just residing there. That's a residential facility. That's silly. This requires a conditional use, pure and simple, and we're really not here. It's really not shouldn't be a debate about it. Just let them file a conditional use. You grant the conditional use. We're not opposing it, but the neighbors at that hearing, but can't do it till we have an application and we bring it up on a conditional.
Thank you.
Because that's what I want, is I want the conditional use, not just comments on why it ought not to be in a general, limited commercial district.
There's no other questions for the appealer. I'll take Mr. Duell's question.
I would like the opinion of our legal counsel on the issue.
For clarification, Jay Hinkle is a deputy city attorney. He's representing staff, and I represent the board, so we're going to answer those questions accordingly. So, no, you just to speak into it.
Thank you for your question. Mr. Kaplan has noted already for us that state law does not include drug treatment facilities as medical facilities. Yet he argues that the treatment facility that is in question here is not a group home and is instead a medical treatment facility. His own citations run counter to what his argument is. The zoning administrator's decision accurately reflects where this particular use best fits in to the scheme that has been developed under the code and has given ample and very detailed explanations why. There is a significant difference here that Mr. Kaplan has not raised, and that is the issues that he seeks to have included through a CUP application And primarily, he's talking about security issues, and it brings to bear the essential difference that the zoning administrator identified, the difference between a voluntary placement and a court-ordered placement. Court-ordered placements exist because individuals have broken the law. They have been convicted, or they are under diversion agreements for a violation of either a misdemeanor or a felony. I agree that under those circumstances, and it's appropriately already exists under the code, that in those instances, a conditional use needs to be requested, and there needs to be an opportunity for a hearing for the members of the neighborhood in the appropriate area. But that doesn't exist here. The people have come there for a residence. The definition doesn't indicate any length of time, as I recall. They're there for the meals. They're there for the place to live that Mr. Kaplan's talking about. And they're also there for drug treatment, which state law tells us is not medical treatment. And therefore, there's no other definition that fits as well as the one that the zoning administrator picked.
We may come back to you. Thank you. Yes, Mr. Warren.
The question I've got, and I'm anticipating that we may have testimony from the audience later on, is why they don't want this facility here. Our job is strictly to determine whether or not the administrator has properly interpreted our existing code rules. Is that correct?
That's correct, and you do so from the perspective that his interpretation is correct. It is their burden to disprove that assumption.
Thank you.
Okay, any other questions for the appealer? Seeing none, let's have the applicant. Is that correct?
Property owner.
Huh?
Property owner.
Owner well, okay. Owner. But they're the ones that.
Good afternoon, Brian Lindeback, MKZ Engineering, 411 North Webb Road, on behalf of the owner and the tenant of the property.
And this is, my name is Ed Watson of Folston Seifkin, 1551 North Waterfront Parkway, Wichita, Kansas, on behalf of the applicant. We are here to address the questions. I think I want to begin. Thank you, Mr. Hinkle. You said mostly what I was going to add to the pudding on today. And just to remind the board where we are and the perspective from which this appeal needs to be viewed and considered. And I see the zoning administrator as a subject matter expert in terms of interpreting the meaning of the code and the statute and applying the facts that they've received. And even Mr. Kaplan has alluded to this notion and conceded that a review of the facts would bring you to the question of what category should this facility fit in. And so the zoning administrator, which was in the best position to look at the facts in the application, determined that it was properly zoned and that this use was appropriate. And so my understanding of the code, and as Mr. Hinkle has indicated, that the burden or that the decision of the zoning administrator should be given great weight, and that the burden of persuasion rests on those who are appealing to show you that the zoning administrator was absolutely incorrect. And it is our position that they cannot because this designation is proper, that this is the things that they focused on in terms of security and in terms of who are the people that are using this residence. It's absolutely inapplicable. This is an absolute, this is a volunteer a place where people go to live. They eat their meals there, they stay there, and they can leave voluntarily. Mr. Lindenbach will speak more to the specifics of the application and the use and how this the owner uses this property. But again, the burden of persuasion rests with the appellants, and they, I think, have failed in that regard.
Thank you, Ed. We have a brief presentation, just so everybody's aware that we are in obviously support of the determination of the administrator. We are representing BRZ Investments and Bellstar Healthcare Services. I think Dale did a good job of describing the area, but just to reaffirm, 1970, this whole area outlined in magenta, as well as this shopping center up here, was part of the CUP. It's actually one of the largest CUPs in Wichita, covers about a half mile north and south. This is the parcel in yellow, which is in question. The parcel in black is the southern part of that parcel. This kind of just reiterates a little bit of what I said. It's been LC zoned property for all of my life, so that's quite old. The duplexes were built in 1980 and 81 that abut this property. The subject property remained vacant for 34 years. Then in 2009, the previous zoning administrator, reviewed this and determined that assisted living was an appropriate use. And if I can remind you, assisted living is a residential facility where people receive care if needed, and they eat their meals and sleep there, and they can freely leave at their leisure if they so choose. This property was developed in 2010 as that assisted living facility, and then was vacated in 2015. The zoning administrator was contacted again in 2018, and the property was evaluated, and they determined that a group residence general was allowed. I think it's very important to distinguish group residence from the various other group homes and things that the appellant mentioned, but this is a group residence general in definition. The tenant made improvements and opened doors June 13th, 2018. The property is an allowed use under the commercial zoning classification. There are many zoning uses under LC zoning classification. And just remind you, it was zoned, my lifetime ago for LC. So it's been LC for a number of years. So it's assisted living, medical services, hospitals allowed use, motels, hotels. Those are just to name a few, but also group homes are allowed, commercial, group residence limited. So there's many types of group residence that are limited, that are allowed, not only in LC, but also GO, if staff wants to reaffirm that feel free. But this parcel has abided by all the CUP provisions. They've abided by all the landscape codes, the setbacks, and the heights, and they're compatible with the surrounding land uses. I think from a personal standpoint, I think this is one of the gems in the area as far as design and land use. As you can see from the photos, it's very well cared for, very well thought after. It's just a really nice piece of property. There's an aerial just kind of depicting the property, and then this is just a list of some of the facilities' current programs. This is the notification list that was distributed. I verified personally that all the notification properties have been notified in the 350-foot list. And then this is just a proximity to the appellant. The appellant is here. Here's the site in yellow, and then here's the other appellant, which is 3.75 miles away as a crow flies, and 5.6 miles by road. So I question what is the aggrieved situation with Mr. Eck. And I'll stand for questions.
So Brian, what your contention is that this is a residential residence, the residents of which happen to be getting drug treatment?
That's right. It's a group home, a group residence general by definition. and the activities occurring on the site are for that use. And we want that use to be upheld with what the zoning administrators' logic and discernment have set forth.
And it's been pointed out to us, this is not medical treatment. Drug treatment is not medical treatment.
It is there's medical supervision as needed.
Mr. Dewell.
Just to confirm, there are no court-ordered residents at this facility, is that correct?
Absolutely not. It's the whole notion of this particular facility is that it is voluntary. People are not locked up. They're not locked in, and they do not take court-ordered clients or patients.
Any other questions for the owner? Okay, at this time, we'll go out to the audience for comment, and each of you have 3 minutes. I hope. Yes, Mr. Foster?
I had a quick question.
Second, Mr. Eck, is it? Just a minute.
Excuse me, Mr. Eck, I did have a quick question for you. I noticed a couple other facilities are listed, I believe, out of state, but my question is, it says here, Wichita-Sedgwick County Unified Zoning Code does not list substance abuse, detox, or addiction treatment facility as a specified use.
Raise that issue then.
Given the epidemic that we're finally paying attention to exists, based upon your experience in these other communities, does the Wichita code need updated to provide for these types of facilities specifically? And what have you seen in other communities?
I'm not an expert in the other communities. They're in other states, other jurisdictions, and so how they legally or how they classify places and give their zoning permits, I can't speak to that. What I can speak to is that the zoning administrator looked at these circumstances and determined that the use that's being proposed by, or is that not just proposed, but actually being executed now by our client is very similar even to the use that was there before, which was the assisted living facility. So in my view, if you just look at the fact that we have here, the code does not need to be revised. But to compare it to other jurisdictions, I can't speak to that. To answer your question, maybe someone from staff can. I just haven't done that analysis.
And I would just add that, whether it's an epidemic now, I think that's debatable. I mean, there's always been substance abuse since substance abuse was around. So, I mean, to say it's more impactful now, I don't think we can speak to that either.
Okay. Thank you. Mr. Eck, were you, I think you were identified as an appellant. Appealant?
Yes, Mike Eck.
Mr. Eck, I'm sorry, but you've been represented by your counsel for the time allotted, and the only way you can speak additionally would be if a commissioner would have a question of you otherwise, but your time has been used, and there was no reserve provided
10
when Mr.
minutes was
Kaplan
used.
spoke, yeah.
So, Mr. Foster?
My understanding is at the discretion of the chairman, that time can be permitted.
Additional time.
Correct.
Before I make that ruling, anybody would like to ask him a question? Okay. Yes.
I think it's a fair question that Mr. Brian brought up as to the being 3¼ miles away. What is the purpose?
We don't make those judgments usually. If he wasn't part of the appealant, I don't think we'd be questioning that. We never do.
I want to understand the why of it.
That, you can ask that question.
Okay, I'm going to grant him 1 minute to start with.
Mike Eck, 12901 West Alderney Court. I would have answered this question before you ask it if I would have had some time, but I got involved in this because my wife and I are we have optioned a lot at 135th and Kellogg, that new residential development, and there's a paint store right next door, retail paint store, and I haven't checked the zoning, but if it's zoned LC, then if this is approved today, that a substance abuse addiction treatment facility can be located in an LC district, there could be another field view located in my backyard of a new house we build. And to that end, I am concerned that I don't know how many of you folks live in an LC district, or if you do, if this is approved, a drug and alcohol addiction center could be located in your backyard, just as some of the neighbors here. The permitted use of LC is single-family, duplex, assisted living, group home, and group residence general. Under the definition of group residence general, it includes 15 persons,
I'm
including...
kind of interested in your argument. I'll give you another minute, and that's it.
Thank you. I'll finish quickly. The definition in the code of group residence general, which we now know this has been defined as a group residence general. It was a group home, that's for disabled, but a group residence general means a group residence that is occupied by more than 15 persons, including staff members who reside in the facility. I don't know any staff members who are going to reside in the facility by definition, but my purpose is personal, the home building, and from an advocacy standpoint. Yeah, it's been zoned LC for how many years? But right now, we got any LC district, you can put if this is approved, somebody can put a drug and alcohol rehab center in your backyard, plus detox, plus partial hospitalization.
Thank you. All right. Anybody from the public, in addition, like to speak? Please state your name and address for the record.
My name is Forrest Cornwell. I live at 544 South Woodchuck. I look out my back window, and that's what I see. You think it's great, but I have a couple of questions. One is when this facility was built in 2010, a hearing came to the public like what we're asking for here. I didn't come because it was a assisted living center, and I really didn't have a problem with that. I didn't have a problem with that because I go into them regularly, see no problem, everything's good. In my ignorance, I didn't know that there were questions I really should have asked. So I'm here today. The first question I should have asked was, what happens if the assisted living goes out of business? What comes in next? And the second question I should have asked is, will they clean up all their mess? Marco is my neighbor. He sent you some pictures and things. In the back of that is a mess. There is their leftover construction dirt and 2 mounds, and it's grown up, and it's very bad. I've called the city twice about it. Nothing's been done. On other occasions, people are dumping back there. I've cleaned it up personally and hauled it off personally. One time it got so bad, I had to call the city and have whoever owns it to clean it up, and it was. I cut that grass back there along that fence line. I trimmed those trees. I make sure it looks good because I don't want where I live to be a dump. So I have a problem with that. And the second question, the first question is, sounds like to me you're just changing the words so that you can make it fit into the zoning code. It's like what Bill Clinton said in the late 90s when he was caught in a sex scandal. He says it depends on what is. What your definition of is. In this case, it sounds like your definition of is what you want to make it fit. My wife works for a law firm. I like those lawyers. I'm not sure that I like lawyers today. Thank you.
Any questions for the presenter? Okay, next person.
Susan Ackerson.
Are you here with the appellant? Are you representing the appellant as well?
Yes.
Okay, then you're not allowed to speak either.
I'm a resident within very few feet of the place.
I will give you 2 minutes.
Thank you. Susan Ackerson, Trust, 547 South Woodchuck. We were notified first by people putting flyers, like you do for a car wash, in our windshields of our cars and our trucks, that, hey, there's going to be a drug and alcohol abuse center. That's not the way to do it. You don't stick a flyer in their windows of their vehicles. You do that like if you're doing a car wash or something like that. That's how we discovered the place and found out about it firsthand. I personally have lived there for over 35 years, and I do not feel comfortable with the system as it is, with the drug and alcohol center. It's too close to a school that's just down the street from us, and there's a lot of children in the area. I understand you're saying it's for volunteers, but what is it to change? What prevents it from changing where it becomes a court order or to go there? Or they have a decision from the judge or whatever, or their doctors or whoever, saying, here's your choice. You either go there or you go to jail. I just think we need to rethink it and rezone it properly. Thank you.
I guess just to answer your question, if that did happen, it wouldn't be allowed. So. And also, I think Mr. Kaplan had represented to us that you were not here to oppose this, only to give suggestions. And I haven't heard any suggestions yet, except not to be here. Mr. Green.
Yeah, Mr. Chairman, that was going to be my question, specifically that Mr. Kaplan said that the applicants were not in opposition. They just wanted to have the ability to make suggestions.
The applicants may be
so
different than
far,
the
all
owners,
I've
I've
heard
concluded too.
is opposition to this. And so I think we should be limiting our testimony to those folks that are speaking specifically to what we're having to address here, the interpretation by the zoning administrator.
I don't think I'd be comfortable making that determination. Willing to hear whatever people want to talk about. Next, you want to speak to that? Okay. Next speaker, please. Oh, just a minute. Mr. Blick had a question for the speaker. Could you go back up, ma'am?
Yes,
I apologize. I tried to stop you in time.
that's okay.
If we could go back to the map, if one staff could help her go back, can you show me where your location, where your house is to the
Sure.
adjacent property?
There's a mouse there. No, ma'am,
You'll just use the mouse.
I don't know how to use one.
There isn't. Oh. Let's see. 1, 2, 3, 4. I'm right there.
Okay, you're
You
just
were
right
outside the no vacation area.
No, I'm not. I'm in it.
Okay, so you're inside the red line?
Yes.
Thank you.
Thank you. That's the question. A second question.
Okay, Mr. Foster, just a second.
I notice in this listing here, there's several pages of neighborhood signatures, and yours is the very first one.
Yes.
And item 3 here, we recommend that Fieldview be required to obtain a conditional use permit prior to continuing to operate. My question is, in the discussions and all these signatures, even though my understanding is we cannot deal with conditions here today, what conditions have been discussed that might be placed upon this property?
Please explain your answer a little more.
Security may have been mentioned. Fencing, what kind of conditions might be placed on this?
We've, talking to the residents, we've discussed fencing, putting fences up, if there isn't like a regular security type system in it. Yeah, fencing. It depends on what type of drug treatment people are going to be there. If you're talking hardcore drug addicts, that might be a little more issue than someone, that's not a hardcore drug addict that's there.
Just to kind of get to the heart of it, anyone from the public, we would appreciate understanding this issue of conditions a little bit better, and perhaps it's a question for Mr. Kaplan, but I'll save that for him for later. Thank you.
You're welcome.
If there's no more questions, the next speaker, please. State your name and address. And maybe even show us where you live.
Okay, my name is Carol Dagg, and we have two properties that backs up on the property, basically where this new facility is. There's land behind there, and our two houses face that land. No one in that residence is happy about this going in, mainly
Did you
because
give your
how we
address?
found out about it. I've called over there several times asking questions. And they pretty much referred to me, oh, we're from California, just contact the people in California. I can just want to tell you that the whole neighborhood there and the school and Target, none of us are happy about this. That's basically all I wanted to say. We're just not happy about it.
Could you state your address?
432 South Woodchuck, and we own 432. We have two properties there.
Thank you. Any questions? Rob?
What are you opposed to about it right now?
Well, mainly because it is a drug and alcohol rehabilitation place, and that it is kind of free. That's a vacant lot. We have a lot of families that go back there with their dogs. We even have a fence that we have made 2 gates where we can go out. Nobody's comfortable with it.
Notice anything arising from the facility itself that would cause
I'm
you-
sorry, I'm a little hard of hearing. What?
Is there anything that's during the operation now of the facility that's
Well,
causing
we've
you-
had a few people that go out there and sit on their decks, and they've had a lot of people running around. That kind of alarmed them a little bit. Didn't know. We've found different things happening since it's opened up. They tell us there's no treatment going on there right now, but my goodness, there's like 30 and 40 cars there every day. Not so much at night, but a lot of people there during the day. But they say they're not open.
So I guess my only comment to you would be, since these people are not ordered by the court and have no record, they could be living next door to you too, right?
Well, I don't think that's so much different whether they're court ordered. A lot of times if they're court ordered, I suppose they're just forced to go there. But it's just not comfortable.
I understand. Okay.
I mean, we've got a nice, wonderful resident, everybody living there, been that way for years and years, and we're just not happy about it.
Thank you. Mr. Warren.
I understand I understand that the fact that you're not comfortable with it. The only thing that we have to determine today is whether or not the city administrator properly applied the definition. Do you have any reason to believe that he did not apply properly the definition of a group home?
Well, it doesn't sound to me like they
Please
did make
speak into the microphone.
it should be
Ma'am?
probably noted as a public facility, I would think.
Thank you.
Thank you. Anybody else? Next speaker, please. Please state your name and address.
Tim Colley, I live at 422 South Woodchuck. My main reason is that I do not want anything that has to do with drugs in my neighborhood. Whether it's voluntary or not, these people have and had a problem. And I think one thing that we live outside of the 350-foot residence, but if you look right down there, that's an elementary school. And I'm thinking that there could be some problems that that school doesn't need. So that's all I've got to say.
Thank you. Next speaker, please. No one else wishes to speak? If not, we'll bring it back to the commission for rebuttal. I say we're going to bring it back to the commission and allow for rebuttal. Are we giving him 3 minutes? And we will not start 2 minutes, I thought, for rebuttal, yeah. Once you get to the podium. Yeah, it's 2, that's right. I never know.
Let me see if I can untangle this just a bit. I had not planned, and I don't represent the public here, I do represent the applicants. The idea is that I want to see the code amended or supplemented to make provisions for something it makes no provision for, and that's a drug abuse and alcohol treatment center, and to put it in a category where it requires a conditional use. Why? So that we can have a conditional use hearing, which is not before you today, and so that the neighbors, when they think about it, can come up with suggestions as to what they want to see in the way of fencing, lighting, no permitted door locks, things that provide security from this facility. And that's what this is about. We're not opposing, my clients are not, we're not opposing the facility, and Susan made that very clear in her letter. We're just simply saying, require a conditional use. I don't understand, and I don't see the distinction, and that's the difference between planning and I. They say that a court-ordered facility is different than a private facility. Why is it? They offer the same treatment, they do exactly the same thing. But why is one a conditional use and one not? I don't understand that. So all I want you to do is, in some way, amend the code. If you don't want to give it a conditional use, at least find a place to insert in the code a provision for drug and alcohol treatment facilities. It's a hot button subject today, and the zoning code should cover it. So that's all I'm asking, is ask them to file. I'm not going to come up here and oppose their conditional use. I'm not going to try to put them out of business. But we may have a list of suggestions at that time, including lighting, fencing, lock the doors, don't allow people to wander the neighborhood at night.
Your time's up.
Got it. All right, Joe.
Let me ask a question. All we're doing today is ruling on whether or not a proper decision was made, right?
Correct.
We can't impose any conditions on this property as it exists now.
Just a legal issue, Joe.
I didn't ask you a question, sir.
Sorry.
Your time's up. Yeah, it's Mr. Foster. But you do have a question here, so.
Mr. Kaplan, one question for you. Is there any zoning district that you feel this type of use, if it were defined in the zoning code, would be a permitted use?
I don't think it would be a permitted use in any zoning. I think that it ought to be paired with the conditional use required under that provision that deals with court-ordered facilities. I think it should not be limited to a court-ordered facility. A drug and alcohol abuse when within 750 feet of a neighborhood, which is a requirement for the conditional use, it ought to require conditional use. That's all. It's no different than the provision requiring the conditional use, and it's within 750 feet of a neighborhood. And I'm not talking about this case, I'm talking about any case. We just can't have we just can't have a blank page on this issue. And that's what we got. And you need to modify it in some way. I don't much care how you do it, but we gotta have a code provision. We've got to have some control, and we've got to have some direction. It's really that simple.
Okay. Now we'll bring it back to the commission for discussion. Mr. Duell.
Comment, I don't think that this body is the one that makes changes to the zoning code, and it sounds to me like that's probably what's being requested. We've had the opinion of the city's council on this, that this is in compliance with the current zoning codes, and this isn't the place to discuss changing the zoning codes.
Any other comments, Mr. Foster?
This is a question for Dale.
I'm sorry, didn't hear the question.
No, I haven't asked you.
Oh, okay.
The question is technology, cultural, all sorts of things changes over time. And zoning is amended over time to reflect changes. For example, the recent big one the city went through was the sign code, which became is a separate ordinance now. My question is, you know, I contend that this specific type of epidemic and treatment is relatively new. It's not addressed in the zoning code. My question is not whether the interpretation relative to what is existing. The question is, does a definition need to be updated in the zoning to provide for this information and perhaps a change in how these are treated, a change in how these are treated?
Certainly, it could be studied. The Planning Commission could ask staff to review it. I don't know how other communities handle it. I don't know whether there is an issue with the HIPAA laws, that if you specifically put drug and alcohol treatment in as a use and then classify it, whether that would be considered violating HIPAA law because it's so specific about what you're treating for. But aside from that, certainly there could be a way to amend the code to create a category that would include this if that's the will of the commission. But I guess what I feel like this is, and I may not be using the right term, but this is somewhat of a bait and switch, because asking for the interpretation of whether this use is appropriate or not, and then saying that what we need to do is change the zoning code to take care of this, an interpretation is not the way you do that. You ask the commission or the council to amend the code to address the issue. And as you have rightly pointed out, the only issue here is whether the zoning administrator properly interpreted the code as it exists today. And if the commission feels that the code does not sufficiently address this topic, you could direct staff to review it and come back to you at a later date with some proposals.
Mr. Warren.
I'm going to make a comment and then a motion. There is a difference between a court-appointed facility and a voluntary facility. A court-appointed facility has got people in it that probably don't want to be there and are being forced to go through a program. You know, there are those people that recognize they have a problem and want to get better and need help to do that. And that is I think that's an important distinction. But for purposes of what we're coming through today, the decision is, you know, did our administrator make a proper decision And I believe that this does classify as a group home, and I would move to affirm the decision of the administrator.
Mr. Green?
Mr. Chairman, I would like to second that motion. I would like to second that motion. And I,
Okay, and we have a motion on the floor and a second, and now do we have any discussion?
and I would also like to concur with what Commissioner Warren said concerning the difference between a court-appointed facility and one who is voluntarily going to a drug facility. So, yes, with that, I would like to second the motion. And I'm assuming that you're wanting to use the format here from the handout.
The motion would read, we have two handouts, one to affirm and one to reverse. And you're saying you'd like to use the motion to affirm?
To affirm, yes.
And in the detail that's written?
Yes.
More discussion?
I'd just like to make the comment, I mean, given the condition of the code as it stands now, it seems appropriate, the motion.
I think I would agree with that, but I would think, my comment would be that I think Mr. Kaplan's raised some good points. And I don't know where, I'd like for us to take some action going forward. Not today necessarily, but going forward. Any other comments? Oh, Mr. Hinkle.
Thank you, Mr. Chairman. Although it will not affect the decision to be made today on the substantive issue, it may be important in any future appeal that comes to draw a distinction based upon the testimony that you heard today. Mr. Eck testified that he has no interest in the subject property. His interest related to an LC property that fronts on 135th Street that is adjacent to a property that he has an option on.
Or I also took him to say any LC property.
Well, absolutely. Mr. Kaplan, I think his argument makes clear that they're interested in any LC property ultimately. That is a request for prospective relief, not for individualized relief on this appeal, and it's not relief that you have the authority to grant.
Right.
Joe, as far as Dale's comment, as far as, or the staff looking into possibility of changes to the code that would apply to this, I would like to see the staff do some research on it and come back to
Let's
us.
hold that for maybe a follow-up motion.
I might interject. You're currently sitting as the Board of Zoning Appeals. The Board of
Right.
Zoning Appeals does not have granted the authority under the Unified Zoning Code to direct changes. You'll have to do that as the Planning Commission.
We'll take it up under other in the Planning Commission. More discussion, relevant topic here. So are we ready to vote? So the motion is to affirm the decision of the zoning administrator, and as detailed in these 4 items on the handout that we have. Does anybody feel the need that this should be read in total? Okay. All in favor, say aye. Aye. Opposed? Okay. It passes. We affirm the action of the zoning administrator. And at this time, we will close, I believe I can do that, the BZA meeting, and call the meeting of the Metropolitan Area Planning Commission to order. Okay, I think our first item Item 3.3, city vacation of 30-foot platted setback to a 0 setback on an LC limited commercial zone lot. Who wanted to hear that? Okay, did you have a question or do you just want to hear it?
I just had a few questions for staff.
Anybody in the audience wish to hear this item? Okay, so why don't you go ahead and make a presentation?
Okay, this is vacation 2018-17, city vacation of a platted 30-foot setback to 0 setback. The applicant is seeking to vacate the platted building setback on the south side of Lot 1, Robson Heights, 2nd Edition. The lot is zoned LC Limited Commercial. If approved, the request would reduce the platted building setback to 0 feet. The Unified Zoning Code's minimum front setback standard for the LC zoning district is 20 feet. The applicant's request exceeds the minimum setback set for LC zoning. However, approving this vacation will establish the 0-foot setback along the south property line. None of the public utilities had any objections. Public Works did ask that they accept the 30 feet on the west end, and the applicants were happy to do that, and they've submitted a new legal description to that. So here is the property. This is the 30-foot building setback that they are vacating. They're going to accept the 30 feet on the west side over here. So they will only have a 0-foot setback along this portion right here. Be happy to answer any questions.
Mr. Blick?
So a question I have is that map right there, the site plan. So that structure that's on the south side that's right there, is that what the proposed building, or can they possibly move that all the way out to Seneca if they want to as 0 lot line?
This is the proposed building, but as I said, the west 30 feet right here, they are not going to be vacating. So imagine this line continues down here. There will be a 30-foot setback off of Seneca, and the 0-foot setback is just off of 30th Street South.
So the 30-foot would be basically from the edge of the street, 30 foot in, or is that 30 foot from the center of the line?
Property line.
Property
It's
line.
30 foot from the property line.
From the property line, correct, okay. And so that was my biggest question, because when I was reading it, I was thinking 0 sight line. There is, right now to the south location, there's hardly any visibility when you pull up that stop sign. I went out to that property and just looked at it, and so that was my biggest concern, is safety with people trying to pull in, and you got a building now is all the way, that's gonna be at 0 lot line all the way down on the south side of that street, trying to pull out onto Seneca.
So there's no setback required then on the right side of the site either?
There, I believe the current LC side setback would apply.
Actually, the property to the east is zoned SF5 single family, so the setback that controls is the compatibility setback, which is a 25-foot setback.
That'd be required on the right side.
That's correct.
So the only real question here is the setback to the south, which we're saying the applicant's asking for 0.
Correct.
That clear?
That was clear. Thank you.
Any other questions from commission to staff? Okay, agent or applicant?
John Fallis here as the general contractor representing Bell Management. I can answer any questions.
We're making it too easy on us. Okay, Mr. Blake.
Question. So the map that we see, the site plan of in Forest, this is a building that you're looking at putting right now. Is this
Correct.
confirmed?
Yes,
Okay. And the existing building, is it staying also, or is it being torn down?
it's staying.
It's staying also?
Yes.
Okay, thank you.
Any other questions? Okay. Thank you. You didn't use any of your time. All right, anybody in the public, from the public would like to speak on this item? Yes, sir.
My name is Jerry Osborne. I live at 925 West 30th. So I'm one of the property owners on the block. I'm also the, also the neighborhood watch captain for the block. So I'm speaking on behalf of several of my neighbors. We have some serious concerns with this. One was already mentioned, and that's the visibility on Seneca is tough right now on that street corner. And that's partially from the business of Jiffy Lube and partially from South Seneca Car Care, because they both get a lot of business. There's cars parked on the streets on both sides all the time, big trucks, things like that. It's hard to see to get out on Seneca. Sometimes people turning the corner on Seneca coming into the street almost hit cars coming the other direction because you can't see them. If this building is in the way, you're not going to see cars coming up the street. You're not going to see cars on Seneca trying to turn. On top of that, a lot of our concern is it's going to be an eyesore for the neighborhood. I mean, if I asked the city to let me build my house out to my curb, they'd laugh and then they'd say no, because it would be an eyesore to the entire neighborhood. In addition to that, this is basically an expansion of the Jiffy Lube business. My neighborhood has had nothing but problems from Jiffy Lube for years. The employees speed out of the parking lot, they'll squall tires, lay black rubber, they race up and down our street, they'll do 40, 50, 60 mile an hour down the street sometimes. We yell at them, we go down to the Jiffy Lube and talk to the manager. Sometimes they're told, well, that person doesn't work here. And he's like, he's standing right over there changing oil. Early this spring, a 2-year-old almost got hit, and the guy didn't even know it because he was showing off to his friends. I've got pictures on my phone. I can show you burnout marks all over the parking lot, burnout marks coming out of their parking lot and down the street. So they're not being good neighbors to start with. So all of us have got some huge concerns for that. Neighbors have had yard sales, for instance. Their manager at Jiffy Lube will go out and pull the yard sale signs up and throw them in their dumpster. I had some yard sale signs that I spent $40, $50 making nice signs, painted signs that I could use over and over, and they disappeared. And finally I looked in their dumpster and that's where they were. And the manager came out there and said, "What are you doing digging around in my dumpster?" Well, I'm getting my signs out. And I've had other neighbors complain to me that they've done that same thing to them. They're not trying to be good neighbors to start with.
You need more time?
Probably just a couple other things I want to mention that the neighbors see that they complain to me about, and I do have pictures. They work outside quite a bit. Under tents, things like that. They're running air tools and things, and the neighbors are saying, it's really noisy. And like I said, the main thing is we feel like this is going to be a safety issue to start with, just from the sight line, trying to see out on Seneca. And really, for us, the safety is the biggest concern. Because we do have a lot of younger neighbors on my block now. There's a lot of children up and down the block. A lot of families coming through there. But that's kind of all I've got.
Okay, thank you. I just would like to clarify one thing. You had indicated the building would be built on the curb. It will be limited to the property line. Okay? And there is a setback required on the Seneca side. You understand that?
But we live on the side street, so for us to see out onto Seneca, or for people on Seneca who are trying to turn on our street to see us, that building would block that view. And we've already had numerous times where close calls, because you just can't see, because that corner is so congested with vehicles already from the two businesses. And if you're throwing a building in there on top of that,
I think what you made your point was it's vehicles, not the building, that's in obstructing view.
Well, both. Well, I mean, this would block view more.
Okay, thank you for your opinion. Mr. Foster?
Is there a stop sign up at Seneca there?
There is.
Yes, Mr. Green?
Yeah, Joe, I liked your clarification on where that building is going to be constructed. It appears as though there is a sidewalk on the north side of 30th Street. Does that sidewalk extend all the way to Seneca?
Yes.
So what you're looking at is that building will more than likely start at the back of that sidewalk and go north. It will not go all the way down to the curb.
Okay.
Just so that you can kind of visualize what they're proposing to do there. It will not go to the curb. So,
Any other questions for the speaker? Okay, thank you, sir. Next speaker. Okay.
Got a staff question.
We'll bring it back to the rebuttal.
We got a staff question.
Owner applicant, would you like to come forward? You want to ask that first?
John Fallis again. Can answer any question.
Mr. Blick.
Question I have is there another place on that property just for the concerns of safety onto that south side, that south lot line? Is there another way to put that building maybe to the east or the back side of that property?
No, not for it to function correctly as the owners are needing it to. So, and also visibility looks wise, you know, I mean, just being out front there, to just make it appeasing to the eye as far as the business goes. Expansion, correct. Yes, it is going to be expansion. It's going to give some jobs. And also, I'm actually familiar with this area because I grew up on this side of town. So it's actually going to cut down some things because I know there's a school area back there in the back. So I do know 30th does get busy sometimes. So there is, where's my mouse? There's a driveway here and a driveway here. And a lot of times when this stop sign starts getting backed up, people will try to cut across the parking lot. So that is going to stop that to where that can't be done. As far as visually, everybody, you can come up to the stop sign, you'll be able to visually see down Seneca both ways just fine. And then as far as parking goes, parking is going to be put in back here on the back side. So not sure what restraints we would have, so.
Mr. Foster.
The previous speaker mentioned some outdoor activities going on that were a concern of the neighbors. Can you describe those activities?
On my behalf as a general contractor, I cannot. I don't know if Rusty wants to step up here, and I'm not sure if him being the owner, if he's knows what's really going on as far as, I mean, the activities that were just discussed.
Rusty Bell with Bell Management and Development. What goes on right now is there is currently a lift outside that we use for some of our additional services. And with the addition of the new building, that lift would go away. The reason we're trying to expand this building is to be able to keep all of the work inside and away from the residential area.
Thank you.
Any other questions? Mr. Richardson has a question for staff.
Staff question.
Thank you.
I guess I got two questions now. One is outside service allowed in LC? I assume is this LC or GC?
It's zoned LC and it is not.
So they're in violation of code right now by servicing automobiles outside. Secondly, is this, if you go down 30th Street, is that all part of the same plat and they all have 30-foot setbacks?
Yes.
So this should be like, as somebody said, letting them put their house out on the curb. There's an entrance into the residential area. but it's all part of that same 30-foot setback on the original plat, right?
Correct.
Thank you.
I got a question for staff also.
Mr. Florence first.
And there was no line of sight issues when you went out and surveyed that, am I right?
Well, I believe that's the reason that Public Works asked us to have them accept the western 30 feet so that cars on 30th would be able to see up and down Seneca Street. So there's also a sidewalk to the west of the property line here. So the building, which isn't even all the way up to the 30-foot setback, is going to be, I'm sure the applicant knows, but 40 or 50 feet away from the street. So cars that are lined up along 30th Street will have plenty of vision.
Well, even if it's on the property line, on the setback line, it'll still be about 40 feet.
That's my guess.
Does that answer your question, sir? Mr. Florence? Mr. Foster?
I'll just interject at the subdivision committee, when we looked at it, the traffic was a concern as well, and we did ask traffic at that time, staff, and they were comfortable with it. So.
Okay. Any other questions for staff? Mr. Blick?
Notifications, when you send them out, you would, 350 feet from the property line?
I believe 200 feet from the property
Actually,
line.
for vacation, I believe we notified everybody on 30th Street,
Everybody on 30th Street?
over to the next block to the east.
Any other questions? Seeing none, we'll bring it back for discussion.
Move we approve.
Second.
Mr. Green made the motion, Mr. Bill Johnson seconded. Any discussion? Seeing none, all in favor? Aye. Opposed? Can I see a hand of those opposed? So we have 4. We have 1, 2, 3. So we have 7, 4. Passes 7-4. Okay. Is the next item 8? Item number 8, which was the zoning case 2018-00024. And Dave, are you presenting that one?
Yes, sir.
And did we have people in the audience who wanted to hear that? Is that correct?
That's correct.
Thank you. All right.
Thank you, Mr. Chairman. This is Dave Yearout with planning staff. This is a request by the applicant to rezone the roughly 10-acre property, about 9 acres, that he owns. We are on north of Highway 54, Kellogg, on the west side of 135th Street West. You can see it in this outlined in blue. The request is to rezone the property from single family to 2-family. It is this overgrown piece of property at this location that we're talking about. You can see on the future land use map, it's designated for residential and employment mix in the future. Picture of the property. This is looking kind of northwest at the property from 135th Street. You can see the number of cedar trees that overgrow the property as present. There is the drive approach that does exist into the property off of 135th Street. But this is looking directly west into the property as it exists today. This is looking immediately across the street to the east for the at the existing commercial use that's on the east side of the property in question. We're looking north along 135th Street. You can see the sidewalk on the west side of the street and the condition of 135th Street. This is looking south back towards Kellogg or 54 Highway. You can see the stoplights here at the intersection. The applicant, there is, it did not show up in the aerial, but I think it's attached to the staff report. You have a proposed layout of the general concept, kind of a sketch layout of what they're proposing to do with this property. The idea is to put a loop street into the land area, and they are asking or envisioning that the property would be zoned such with TF3, the duplexes, except for, and they're showing within their sketch that the very far west end, where it abuts the existing residential development that's part of the Auburn Hills area, which is really, except for a couple of lots back at this location, adjacent to the drainage structure that exists onto the west. They would keep single family on that west side, and the two-family development would happen more east in the interior of the project. Staff has recommended that we grant the approval, but limit it to roughly the outline that they're showing in their sketch, to where the far west end of the property, roughly about everything except that much of the land area would be zoned TF3 in this portion of the property, but this strip of land would remain single family. That's the staff's recommendation, with the idea that we would tie that to either a legal description the applicant would provide, or hold the publication until the plat was presented of how they intend to develop the property. So I'll be happy to answer any questions you have.
Question? So do you have any idea what the depth of that single-family parcel would be on the west side? Because wouldn't the legal description for the zoning have to change?
We did not end up with a hard measurement. It looks to be in roughly like 150 feet, something in that neighborhood, maybe a little longer when you get the street right away involved, but.
You're recommending approval with that change?
Yes.
Are we talking about duplexes or fourplexes here?
This one is duplexes. This one is to TF3 rezone. You may have the wrong application, because the next one will have the fourplexes.
David, there's no opportunity for any access off of that west side, is that correct?
Correct. As sketched right now, it's just a loop street.
There is intervening property between the street right of way west of the property and this property that's reserved in the Auburn Hills addition, so there is not.
Looks like there's a little bit on the very end of
Oh,
it.
yeah, maybe not enough for a street right of way.
Okay.
That's correct, you're right.
Thank you for that distinction. I was on the wrong one. Any other questions for staff? Seeing none, agent or applicant?
Good afternoon, Logan Mills at 1935 West Maple with Certified Engineering Design. I'm here to represent the applicant. I guess I'd like to give a little background on the project. First of all, the developer here is local. He's owned this since '93. As you can tell, it's been overgrown here with cedar trees. He's planning on, duplexes is a term that's been thrown out, but he's calling them garden homes. They're geared towards 55 and up. And again, we'd be keeping the west end as single family, the 5,000 square foot. I can get a dimension. I don't have that off the top of my head, what depth that is. Let's see here. Yeah, the thought is to have no maintenance, again, for the 55 and up crowd. So be done with the homeowners association. Let's see here. Reserves. Reserve A would be outlined for a pond for detention purposes. We've got a Reserve B and C shown as well. Either Reserve B would be more than likely a maintenance building for the development. And then Reserve C, unfortunately, sanitary sewer is not very deep in this area, so we might have to install a lift station in order to solve the sanitary sewer issue. So that's what that is outlined for. There is, if the limited commercial on the east side ever expands or ever gets going, then they should be extending sewer, and we might be able to extend it farther from there, but that remains to be seen. I believe that's all I have. If there's any questions, I'd be happy to answer them.
Mr. Foster.
Will the off-street parking needs be met on the lots themselves?
We're looking at the off-street parking would probably be in the driveways. The roadway width we're looking at is the 32-foot wide right-of-way with the 15-foot utility easement outside of that. So that's what we're looking at there.
Mr. Blick.
Question I have is the existing properties that are to the west, are you proposing any of using any of those existing vegetation or landscaping as a natural buffer, or are you just basically going to go right up to the lot line?
That'd probably be the choice of whoever buys the lot. I don't think the developer's planning on living here. I don't know he hasn't decided which lot he wants to pursue, but I would assume whoever owns that has the choice to leave a buffer or not. But I don't, it's single family to single family, so I don't know why you'd want a buffer, I guess.
I was just wondering because I know with existing people live nearby, they're used to seeing a wilderness out there, and
Sure.
now all of a sudden there's houses, and so that's why I was just wondering if you were leave anything or not. So
We don't have any provisions. We can talk with the developer and
it's
see.
no biggie. I was just wondering. Thank you.
You call these garden homes, why would they need a duplex zoning?
Well, the thought, I think duplex throws a lot of people. I mean, these, again, I guess when I'm talking garden homes, I'm talking duplexes for, yes, 55 and up. It's not, they're going to be low maintenance, zero entry. Again, I don't know
They are two-family unit, the units are two families.
Right, yeah.
Are they rentals or for sale?
I can't answer that question. I don't know.
Obviously, if it's for sale, it'd have to be lot
Right.
split, right? Have to be platted, yeah. Is that right? You okay?
Well, the ownership of the property could get very complicated, and it's not.
Not for us to decide today. Any other questions?
To answer your question, I mean, I think the developer's been talking with duplex builders, but I don't know as the extent of renting versus owning.
Okay, we'll go to the public for comment. Who's first? Please state your name and address, and you have 3 minutes.
Roger Rumpf, 13712 West Montecito, and I'm kind of outside the notification district, be in the Epcon community to the north of this
Sir, can you use the mouse and show us?
third lot. Well, there's the lot in question, there's a residential, and then our development.
Use the mouse.
Our development is here for,
Okay.
it's an Epcon community. It is Perfection Builders, and they have just been able to procure all the property across the street to build 135 more units there, which are single-family patio homes, okay? I'm just here to speak for a general area as far as the planning commission. You look at planning, you look at the whole area. Auburn Hills has been a vast upscale community for years. It's still building. It's just about finished. And you have to look at the whole picture about that area. Mr. Edgington has just kind of come up with this idea. It sounds like pretty nilly-willy as far as everybody's concerned in the whole neighborhood, and hasn't come up with a good enough plan to have you all understand what he's trying to do. The basic premise here is and believe me, we're not against any development. We're not against any more neighbors in the area. It's a great community. It's a great area to finish development. But the basic premise is we don't know. He has portrayed this property, has owned it for several years, has portrayed this property as agriculture right up to 2015. 2015, then he couldn't prove it was agriculture anymore and had to start paying taxes on it. So obviously, then he decided, well, I'm not going to build a single-family home. He wanted to go into this idea of multiple-family home. So the basic premise is he's being called a developer. I don't know that he has the means to be a developer. Anybody can be a builder and a developer, I guess, but who are going to be his builders? What I guess in very plain terms, what quality of homes are they trying to put in there? And if they do go strictly rental, that does not fit the area of Auburn Hills. There are no rentals in Auburn Hills, except very on the southeast corner down in Auburn Hills over by 151st Street. I won't go into detail there, but there has been complaints that as rental properties, it doesn't have quite the control you have of a solid HOA with medium-priced homes, probably I'd say in the whole half a mile to a mile area of 300,000 plus. The builder right across the street, Perfection Homes, is looking at building some custom home in there, probably over $500,000. So that's all we're concerned about is we think he needs to come up with a better plan, a better understanding of what type of homes, what medium price of home, if they are rentals, if he moves there or not, if he doesn't move there, whose HOA is it going to be under? Who's going to be in charge of that property?
Sir, your time is
Who's
up.
going to control that property if he does not live there himself? Thank you for your time.
Next speaker. Do you have a question for the speaker?
Just a quick question, sir. You feel this property is more appropriate for some type of commercial zoning?
Type of what?
Commercial zoning?
No, not necessarily. Again, those are very prime properties. There's two custom homes just to the north of those, two single custom homes on the bigger properties. That's fine if you put in multiple units in there, but we just don't know. Your average homeowner in that area just has to have a negative opinion of rentals, any type of a rental. Unless it is an upscale, what you call condominiums, which are sometimes rentals versus ownership, but we know those are high-end condominiums that will be maintained properly. He could end up putting in 1,200 square foot duplexes that are not high quality built, and then you end up with 14, 15, whatever he wants to put in there, of rentals that are super lower than the medium price of homes out there. And I don't want to get into socioeconomics, but everybody knows, everybody's had that experience, that if you don't have the higher end custom homes, which are within a mile radius of this, then you end up having, you have issues. You will have issues, especially for the people behind them in that court that probably have $300,000 homes. If he just builds low-end rentals in there, it's just not a good mix for that whole neighborhood.
Thank you.
Single family here, it doesn't. Next. Excuse me. I was getting clarification. Next speaker. After he speaks. Mr. Miller has a comment.
Just a clarification for the speakers and a reminder for the Planning Commission. The Planning Commission does not have the authority to control whether there's a homeowners association, the value of the homes, what they look like, or any of that sort of thing. The only thing is whether the TF3 zoning is appropriate or not.
Sir, state your name and address.
My name is Jerome Smith. I go by Jerry. I own 1406 South Auburn Hills. If I can find the mouse. Right over here. I also own 13812 West Onewood, which is on the north part of the map. Got two homes in the legends. As far as the Planning Commission with the authority that TF3 is appropriate, absolutely not appropriate. These aren't $300,000 homes, they're $500,000 homes. This development, people came in and bought. It was already planned out. We said we're going to have lesser price duplexes here. We're going to have lesser price single family. We're going to have homes on the golf course. And they're all priced accordingly. Everything's built, everything's developed, and then we're going to come in after the fact with no plan. I got more from the newspaper than I did from this presentation today as far as what's going to go in on that property. I know it's zoned single family. If the gentleman wants to put a single family home in there, welcome to the neighborhood. But no duplexes, okay? None. We can't have it. That's as honest as I can be on it. But in total honesty, I see the commercial application of a choice property like that as well, between that and the church. I'm not going to lie about it. But there's no way that it's a duplex. Thank you very much.
Any questions for the speaker? Mr. Blick?
I have.
Sir?
So you said you have two homes in the area, is that correct? So do you rent
Yes,
the
sir.
other home out?
No, it was cheaper for my mother-in-law to live there than look at assisted living for her, to
Okay.
be honest with you.
I was just wondering. Thank you.
Any other questions for the speaker? Seeing none, next speaker, please. Anyone else wants to speak? Okay. I'm sorry.
Problem. Good afternoon. My name's Susie Blasey. I happen to be the lucky owner of the property at, just to the west of this land, this nice forest land. And when one of your members mentioned, we're used to looking at forest in the back of our yard, we saw 3 deer this morning when I got up to go to work this morning. So one of the things that really attracted us to that home is the fact that it butted up to this forest area and nice landscaped area behind. Knowing well that that is privately owned land and that might someday be developed, we were fine with that. There's a really nice property, you can see it on the map, just adjacent to that. A farmer owns it. He has his home there on that 9-acre lot, and no problem. It's just a really nice area. We haven't lived there that long. My husband's sitting here with me. We've lived there just about 2 years. We purchased that home. I'm glad to tell you, we purchased that home for nearly $400,000. We put $60,000 worth of work into the outside. We made a nice little deck on the back side of it. So I really hate to see the property go to duplexes as well. There was an explanation of single-family homes that would butt right up next to our back fence. Essentially, that's where it is, right up next to our back fence. And that's better, single-family versus duplex. But I really do worry about our property value in the end if duplexes go into that lot. That's all I have.
State your address, please.
I'm sorry, 1510 South Auburn Hills Court,
Thank you.
right behind that property.
Right. Any questions for the speaker? Next speaker. Seeing no other speakers, we'll bring it back to the commission for discussion.
About
Oh,
rebuttal.
I always forget that. Agent, you have 2 minutes to rebuttal. Why do I always do that? Just a habit.
Mills again, I'll stand for any questions.
Klosmeyer.
Is this area under any restrictions from the Auburn Hills Homeowners Association or as far as restrictive covenants?
I don't think it's part,
This is a separate piece of property from anything in Auburn Hills.
right, that's
So
the
he
way
could-
I
He
understand
could
it.
go in there and do anything he wanted, single family.
Unless, yeah, that's as
I mean,
far as I
right
know.
now, he could go in there and build anything he wants, single family, and set the restrictions on there.
Sure, yeah.
Okay, thank you.
Any other questions? Seeing them, we'll bring it back. Oh,
Got a staff question?
staff, please. That's for Mr. Warren.
Dave, across the street to the east, there's a number of large lots that are, go back that arrow, please. That are outlined there to the east. What's the zoning on those, on the lots that face out onto Kellogg and the ones that face out onto 135th again?
Most of that's zone GC. It's also in the community unit plan. It was the subject of a rezoning attempt about 2 years ago, for a PUD for an event center that was subsequently withdrawn, and this CUP has gone through, and it's got commercial, and as I recall, the CUP, there's proposed for some patio homes, or whatever you want to call it, the north end of that property. That's under.
Patio homes north and then commercial on the
Yeah,
on the
it's-
lots that face out. That's what, thank you. Okay.
Any other questions for staff?
Not a question, but a comment. The issue with duplexes and rental properties almost always comes down to the aspect of how well they're maintained. And it's the same thing whether it's a single-family home or a multifamily home. If they're properly maintained and really taken care of, they're gonna do okay. Part of our job is trying to figure out where the buffer zones are gonna be, and this looks to me like a lot that is a buffer that goes from very high-end properties to an extremely busy highway and commercial to the east. And so I'm, having lived in duplexes most of my life, I don't have the aversion to duplex life. So I see this as a positive zone change.
Did someone else have their hand up?
Nobody else has a hand, I would move to approve.
I'll second it.
Who second? Mr. Klosmeyer. We have any discussion?
I might just kind of follow up with the way I agree with Chuck on the duplexes, that the ones that have been built lately, and if he's talking to some of the people that I know, they've done a lot of duplexes around as projects, and they handle these projects with care, and they make sure that they're not the stereotypical duplex living. My point on residential, he could go in there and put his own restrictive covenants in there on this piece of property, any way he wants to do it right now. He could be 900 square foot and sell those homes to anybody that could qualify for a 900 square foot home. And I don't believe they will take that type of person that gets in there, will not have the means to take care of the outside like they're used to seeing, whereas the duplex projects, they're do pretty nice. They put landscaping around their trees, fencing that are nice and everything. So I think it's a better deal than what, keeping it single family. So I'd second the motion.
Right now, it's zoned
Single family.
single-family zoning now.
Single family.
Question?
No, I was just gonna make a comment that, this whole area out there is a high-end area, and I this doesn't give me a good feeling for duplexes in there as being compatible. I know it's a compatible use duplex next to single family. I just don't have a good feeling about the plan and the way that was presented. So I'm gonna vote against it.
I'm probably going to vote against it also because I think people that have that type of single-family homes around it and come to build those based on a single-family zoning that exists have a right to expect that, and that's my personal opinion. So we're ready for a vote. All in favor of the proposal?
Aye.
All opposed?
Aye.
So
Who are the noes?
I think we had two. Okay. So that's what, 9-2? Okay, agenda item 9. And is that you again, David?
Yes, sir.
All right.
Mr. Chairman, this request is to rezone the property as outlined here in the blue. We are east of Webb Street on the south side of Harry. It's an odd-shaped property simply because of the manner in which it is laid out. I'm going to give you a little bit of background. This northern portion of the property that has GC and GO zoning is occupied primarily with what's known as Journey Church today. The history on this, it was platted out as, and the plat's called Arboretum, and that plat created the extension of Goebel Street coming south off of Harry down to a dead end where it dead ends the bulk of this property. That was done back in the day when that was owned by, it was where Sunnyside Nursery used to exist, as I have been told. The bulk of the property is zoned single family. There is a small neck of land that actually sits on the east side of Goebel Street extension that's zone TF3. They're asking to rezone all that property to MF18. And that's the property that I think you were looking at earlier, Mr. Chairman, that shows a concept sketch at this point with the idea they want to take Goebel Street and bring it into the property with a loop, and then exit back out onto Harry Street. And around that would be a combination of duplexes or two-family and four-family structures that are laid out in the sketch that's attached to the staff report. The reason for the MF18 zoning is to cover the density. This is roughly a 5-acre tract, and when you add up the density, it falls within that category. I think the applicant will address the fact that they're envisioning this to be subsequently as it would end, would have to be platted, because the bulk of the land in this property is unplatted right now. The platting subsequently would be addressing the manner in which they envision the ability to subsequently divide these residential structures, both the two-family as well as the four-family structures, into individual parcels. So it probably would have some zero lot line development concepts that are addressed in the platting process. We're dealing only with the zoning today. And that's what they're asking to do, and that's what this rezoning is about. As you can see, we have the commercial development that sits to the west. The rest of the property, for the most part, is surrounded by single-family development. And as we get into, you can see in the aerial how there is some vacant land to the south, but most of the other stuff in the south and the east is zoned and developed residentially. This is the location of the property with respect to the future land use plan. Pictures we are looking, this is the back side of the church. I'm kind of at the west side of the parking area, actually off the pavement into a gravel area that's on the south. And this is the south end of, or east side of the area. That's the same location, just kind of rotating, looking more southeast. You're looking at the area that's proposed for the redevelopment. This is taken essentially from the entrance off of Harry Street. Goebel Street entrance is right in this area. It would come back in here, and you're looking south towards the site. We're kind of looking down where Goebel Street comes in. That's looking kind of west from the Goble Street entrance. Actually, this is the east drive into the parking area around the church. I'm a little more internally into the property and looking. The land area is to the, oh, it's very sensitive. This is the area, the west property line is roughly right in that area. This is looking across Harry Street to the north. You can see the multifamily development that's on the north side of Harry Street, north of the Goble Street entrance. That's kind of looking just a little more to the north and west towards what's happening on the north side of Harry Street. This is looking northwest. I'm again in the parking area south of the church and kind of looking north and west towards the commercial development that occurs to the west. This is looking almost straight west from the property in question. You can see the parking lot on the commercial development to the west. This is also, again, looking west towards the development. You can see the auto zone here, and Harry Street's right up in that area. This is the entryway that is roughly where Goble Street would come in. So as that area would redevelop, this drive entrance would kind of be redone and made into a street intersection going south. And that's looking east along Harry from the Goble Street entrance, and that's looking west back. This is the driveway entrance into the church, and you can see the development, commercial development that happens on further to the west as you're looking west along Harry. So that's the substance of the request. I'll be happy to answer any questions.
Dave, I've often thought that it'd be nice to have a site plan, show that where the camera is, where the picture's being taken, and then show the picture, and do that on each of the pictures. I think it'd be a lot clearer for us to understand where you're taking the pictures from.
Okay, well,
But I understand that takes a lot more time. Mr. Blick.
Question, the property, the commercial property to the west, is that used to be a Walmart that's over there? Or a neighborhood market or something?
yeah.
It was, so they have, is the stormwater runoff, is it zoned at, I mean, does it flow towards Harry Street, or is that more towards the back of this
What I've
property
heard
line?
from the neighbors is that when you get into the property itself, that a lot of the development, stormwater has a tendency to move back, I think, more to the south and the east. But I'm not in a position to address the full size of that drainage area and what happens. As I've repeatedly said, when this particular property would be developed for whatever purpose, they're going to have to, not only as part of the plating, but also as before they get building permits, going to have to address the overall drainage impact, because we're above the 1 acre threshold. So they're going to have to do a pretty intensive drainage analysis and address stormwater issues and what they intend to do. I would presume, and I'll let the applicant's agent and engineer talk about that as we come forward, but they're going to have to figure out what they do with that, whether it'll be on-site retention or whether they're going to otherwise try to move it to other drainage structures that exist within the area.
Thank you.
Mr. Richardson.
Dave, I got a number of questions here. One, my understanding, the MF-18 allows a 45-foot height, and SF5 is 35 feet. Am I correct on that?
Yes.
Secondly, in your recommendation number 3, you say that the screening and landscaping required would mitigate all impacts of that change. Could you describe for us what that screening requirement will be between MF-18 and the single family?
Well, there's screening requirements between multifamily and you got residential on the south and on the east side. They're going to have to address, and Scott, I'm going to punt to you because you know that better than I do.
There's a number of options in the code for screening. The most commonly used is the solid screening fence, but there are also landscaping and berming options as well.
Okay, but we're not, okay, but we're not going to address the extra height here at 45 feet, which is,
There is also a compatibility height standard that would apply since the properties, at least on the east and south, are zoned single family, which would limit any building within 50 feet of the property line to 35 feet in height.
within 50 feet? Okay, yeah, great, thanks, Scott.
How much denser could this be with this zoning request?
Well, I think you have the ability to go individual, particularly when you're talking about dividing these individual ownerships within their concept. The lot sizes can go down to 3,500 square feet in size as opposed to a 50 or 5,000 square foot for single family. So you're granting the ability for the ownership parcels to be smaller than what you would with single family.
Do you think it's pretty well maximizing this zoning category?
I think that's the intent, is to provide higher density, a little bit like what you're seeing on the north side of Harry Street.
Thank you.
Question.
Mr. Richardson, you had quite a few questions, you said.
I do have some questions. Just to be clear, the street on the south there, Stony Brook,
Correct.
which essentially dead ends for some reason, you have any idea what the plans were for that? I assume this site, does it have access to that? It doesn't look to be,
Well,
but I can't
it
tell.
touches it barely, but we are not seeing a plat, and there are other parcels that are impacted by where Stony Brook dead ends right now, and they're not a part of this zoning action, so, and not a part of any proposed plat. There's nothing we're seeing within the sketches that the intent would be to extend and bring a road to where it would connect into Stony Brook at this point in time. That's never been discussed, and probably would be more of an issue that you would address through the planning process. We've not had a conversation per se with fire department of whether or not they're going to be comfortable with having Goble come in with a loop street with one way back out. We'll have to address that issue through the planning process. I'm sorry, I can't.
This thing is not working.
Oh, it is now. Don't touch it, yeah. You were coming out fine.
Don't touch it.
Yeah.
Can you hear me now?
Yes, I can.
So the original plan may have been to loop Goble Street. We're going to have an entrance into the church right beside Goble Street there, which I realize is a platting issue, but
Well,
is
Goble is platted now.
it's platted for, you made the statement that
From
most of this
Harry
was
to this point, it exists right now as public right of way.
to the back of,
The north side.
or the developed area of the church there, if you will.
Correct.
So it is another dead-end street, if you will.
Right now, yes.
Right now today. Is Goble also platted on the other side?
Well, Goble is existing, at least a public street on the development to the south. The only thing that comes up into this area is the end of where Stony Brook hits, but there's no extension and it's not fully adjacent to.
How about on the west side of the church, Dave? Is that also platted as Goble?
West side of the church. Well, Goble, this is Goble Street right here.
Well, Google Maps says it's also on the other side. I don't know whether that's accurate or not, of course, but on
Well,
the west
it
side.
is, that's Goble Street going north of, when you get north of Harry.
There is no intervening right-of-way west of the church.
There is none, okay. Because it shows a driveway there with a label on it.
Any other questions? I think while you're thinking of your next one. Anybody else? Back to Mr. Richardson. Nope. You're done. Okay. Need the agent or applicant? do okay, Mr. Green?
Kirk Miller, I'm the agent for the applicant. And I believe in the handout, I didn't see in this presentation, but it does show our proposed layout of the site with the loop Goebel Street. And what the intent is to, right now, we're going to do duplexes, fourplexes, and divide them into individual units and sell off to individual homeowners for each unit. Have an HOA that maintains everything. So it'll be the duplexes and fourplexes. And as the discussion was going, as far as on the southwest corner, this property only does cover about half of that right of way, so we really couldn't extend down that way. We did go to development review with this a few months ago, and fire department was there. They were fine with what we were proposing. Everybody was in agreement that this was something that we could do and was an appropriate use. The applicant is here if you have any questions for him on, he will also be the builder.
9 more minutes.
You got a question?
We're-
Kurt, so the fire department
This
didn't
is
ask
what we
for
want
a
to do.
second access?
No, they did not. The rule is 100 units, and we're less than 100. Now, as far as the maximum zoning we could do on this, if we, as MF18, if you're 5 acres, you could actually put in 90 units.
How many?
90,
That's what I
5
was
times
asking.
18, yeah.
That's why I was asking David. So it has not been maximized
No,
with your proposal?
right. We're showing 60, I believe it's 60, but we're showing 6 of those 60 being north of that square, so on right next to Goebel coming in.
Any other questions? Dave? Mr. Richardson?
Yeah, isn't it my turn again? So the owner understands the compatibility setback along the east property line. You're only going to be able to go 35 feet within 50 feet of the, because your drawing shows fourplexes within 20 feet of the property line there.
Right,
So you'll only be able to go 35 feet tall.
right. These will only be 2-story.
Okay, because there was, and the other thing is there's, most of the trees that screen those properties are not on the east, they're on this property. And hopefully there'll be some effort made to save, there's a lot of pine trees along there, and it'd be to everybody's advantage if you could certainly save those. Now that may not be possible because of utility installations, but I would certainly encourage that.
Well, you have sanitary running along there, so it's just a matter of service lines, so
It's already in.
most of that could be saved,
It's
yes.
already in the back.
Right.
Okay, thank you.
Foster?
Just to confirm, Kirk,
Yes.
during that development review, was there any discussion of connecting Stony Brook and bringing it on over to Goebel? It just
Yeah,
seems a
and-
little odd, because whenever we look at these at subdivision, we're looking for those kind of connections, and that didn't come up.
Right. Well, the problem is we don't have full right-of-way there we could do that with. We're only halfway into that right-of-way, so
I got you.
we
Okay.
can't,
Thank you.
can't go into
And that
somebody else's
discussion
property.
did occur.
Yeah.
Would there be any desire to talk to the adjacent landowner and see if that would be possible? Any desire? Probably not.
I don't know.
Is that a fair
We
question?
haven't even had that discussion as to whether we wanted to talk
Hey.
to them or not.
Any other questions for the agent? Anything that the owner would like to comment on?
Anything?
I think the time, I think you got more than 3 minutes.
I won't take very much time. What we envision in there are homes for sale, so these are not going to be rental properties, and what we consider these to be more luxurious type townhomes. So these are going to have granite and wood floors and those type of things in there. So the HOA should take care of any issues with the exterior of the house. That's the intent, is that the yards will be taken care of and will be managed by the HOA association. So if you have any questions on the product, I'd be happy to answer.
Any questions for the owner?
You need to give his name and address.
Oh, name and address.
Clint Miller, 1907 South Hydraulic.
Okay. Seeing no questions, we'll go out to the audience for comment. Yes, sir.
My name's Lee Fraze. I live at 1623 South Red Oaks. I sent in the PowerPoint.
Is that on this map? Oh,
It is, and I can show it to you.
I don't see it attached.
I sent in a PowerPoint to Schliff something,
Jim Schiffelbein.
Schliffenbach or Schlifferbein. He requested I sent it in last night.
We're checking with him.
Okay. I can probably find it on here. Essentially, I live right here. Third house south of Harry. I disagree with this being zoned to multifamily. If I can find an aerial map here, I have my own aerial map.
You'll need to go the other direction.
So my map probably shows it better, but you don't have any multifamily zoning south of Harry or east of Webb currently. This is all single family zoned. What this is going to do is it's going to depreciate the value of the homes surrounding this area. This Harry Street and Webb Street creates a natural buffer from what this is going to turn out to be. I understand what the owner is telling you, but what he's telling you and what in reality it is, it's apartments. This is what this is. This is what this sounds like. Luxury apartments, whatever you want to call it. You can't take a cow pie, polish it up, and it's still not a cow pie, you know? So, you know, you're going to have more problems with traffic, in particular at Goebel Street. There's just in the last month, according to Community Crime Map, there's been at least 4 accidents just at Cranbrook, and you don't have as many units here coming out. He's saying 60 units. In reality, you could put 100. 100 units times 100 cars. If you only take 1 car per family, which that's not what we all have. We all at least have 2, right? So you take that times 2, that's 200 cars that have to come out of Goebel every single day. There's no traffic control issue at that intersection right now. I mean, does the city install a traffic light to fix these problems? These are all things that have to be addressed. And like I say, I'd like to have my pictures up there to show you a better layout of that. But
can you show us with the mouse where your home is?
I live right here, the third structure south of Harry on Red Oaks. So I butt up directly to this. You know, you're going to have noise issues from every single car that comes out of here.
Basically, you live along the driveway and you don't back up to any of the units.
I could essentially back up to what this is classed as TF3 here. I don't know what he has in mind for that, but he could essentially build small structures right here. I do back up directly to this, though. Yep.
Any questions for the speaker? Next speaker.
Hi, my name is Ruth Ryan, and I live at 1723 South Red Oaks. And I live in this, let's see it on here, I live right here. So my backyard is
Speak into the microphone.
looking out to the open field.
Ma'am, could you speak into the microphone?
Sorry. I live at 1723, and I am basically on this end in this house.
Okay.
So for 22 years, I've lived in this house. I built that house, and I stood in that lot. It was a developed neighborhood with 1 lot left, a very small lot. I have a 900 square foot house. And the last thing I asked before I bought that lot was what could possibly go behind me. And I was told that the owner of the Sunnyside Nursery at the time had it was zoned for single-family homes, and he was going to build his personal residence back there. And I was okay with that. So I bought the lot and built my house. So now it's being zoned, wanting to be changed to zones to, like he said, essentially apartments, right up into my backyard, to where for 22 years I've had a beautiful field out there. And now I'm going to have a 2-story apartment lined up looking into my backyard. So my question also is, like the gentleman there had said earlier on a different one, what's the buffer zone between our houses? There's 15 of us in that line that are now going to be faced with traffic, parking, parking lot lights, houses, 2-story houses all invading on our privacy. I cannot imagine going from no neighbors back there to 200, 300, 400 people. And that street and Harry Street is supposed to be able to accommodate that. I can hardly get out onto Harry Street now in the mornings to get to work because of the traffic from the people from Andover. So I can't imagine all of the traffic coming in and out from there, what the cluster that's gonna start right there. So I am very opposed to multifamily homes back there. Single-family homes, I would welcome. Neighbors, that'd be great, but not apartments and as many buildings as they're proposing to put up. Thank you.
Questions for the speaker? Okay. Next speaker.
Good afternoon. My name's Carrie Jacobson. I live at 1711 South Red Oaks, which is right here. Nope, wait. Right here. My property abuts directly up to the property behind us. I bought my property in 1994. At that time, Mr. Tom Mosteller owned Sunnyside Nursery. We had many conversations with him. He told us at that time what he would have liked to do once the land had been plated. He was interested in putting 10 family homes back there on half-acre lots. We thought that sounded great. Since then, of course, back in 1994, this was nothing but wheat fields and small farmhouses. Since then, everything south, hundreds of homes have been built back there, which is great. That's progress. However, my main concern is that we're only going to have one entrance and one exit back into this property. I can't imagine that's not a concern for the firefighters as well. From the plans that I've seen, they want to put 12 fourplexes, which would equal 48 units, and also 12 townhomes, which would be another 24 on this small 5-acre square. In 2016, as Mr. Miller should know, the land over there is a lot of clay soil due to movement. I spent a large amount of money to have foundation issues fixed. I'm very concerned about the water and having any more problems with water. So other than the one entrance in and the one entrance out, if there were to be a fire, I don't see how equipment could get back there without blocking everybody that lived back there from being able to get out of there. So I guess what I'm asking is that instead of rezoning to multifamily, I believe me, as well as most of the neighbors that live there, would prefer that it stay single family as it's zoned currently. Thank you.
Questions for the speaker? Thank you. Next speaker. I'd like, Dave, I'd like to see the plan.
Don't think we've got a copy of that in this slide presentation.
It's really kind of irrelevant because it doesn't have to be that way.
That's accurate. It's
What we're-
not binding, that's for sure.
What we're-
There are handouts typically outside.
Yeah,
Somebody
there are.
might check to see if there's still some out there that we could pass out.
If not, I've got one right here.
Okay, we're ready for a 2-minute rebuttal.
The last speaker said there were 12 duplexes. I believe there's only 6 shown. We only have 60 units. I think her math was a little off just from looking at the drawing. But otherwise, I'd be glad to answer any questions.
Actually, there's 12 shown on your layout here.
12 duplexes?
Fourplexes.
Well, yeah, fourplexes. But she also said, I think, there's six duplexes and 12 fourplexes, which makes 60 units.
Right.
I think she said 12 of each. She may have been thinking 12 total units in the duplexes, probably.
I think your plan shows 60.
We show 60, yes.
As you stated. But again, that's not binding.
I don't see getting any more on there, though.
I don't want to cut into Mr. Miller's time.
I don't know if he had anything else
No,
to
I'm
say.
open for questions.
Go ahead.
I have staff question.
Oh, anybody have questions for Mr. Miller? Seeing none, anybody have a question for staff?
Actually, I do. The folks, 2 folks from the public said they had a question. Well, I'm curious what their questions are because I'm struggling a little bit with this one. Sir, if you would, or one of you, if you'd come up and ask your question, please.
Well, wait a minute. I would allow 1 minute for a person to come up and talk.
It's just a question.
Ask question.
Yeah. Could you please state your question?
Ruth Ryan, 1723 Red Oaks. I'm looking at this now, and I'm seeing that the fourplexes are all lined up right against the back of our single-family homes. So what's the buffer zone? Is there going to be a fence? Is there going to be a line of trees? What is there going to be that I don't walk out onto my back deck and here's the 2-story house lined up. I have nothing but houses lined up. Are they going to have backyards? Are they going to be? I don't see how this is compliant with the zoning is supposed to protect us so that we have houses in our area that are similar to our own houses.
Dave, can you answer that question?
Well, kind of hard because of the scale involved here, but there is a setback that they would have to comply with for a structure. And they're not going to be any closer to the property line than the existing single-family homes are for all practical purposes that are along Red Oak. And as Scott talked about, when you have multifamily adjacent to a single family, which is the case here, as you can see from the zoning, if this is zone multifamily, it butts up. The white is all single-family zoning. There are certain requirements with either respect or solid screening, which is historically or fencing. Solid fencing was historically a privacy fence, indoor landscaping, or there could be a berm, but that's a code issue. And they would, at the time, they would come in with a site plan for the construction. They would have to address how they're going to meet the compatibility setback requirements of the zoning code.
The other thing that would be required is that the landscape ordinance will require a landscape buffer as well. Well, there's a number of different options, so multiple ways in which it could be provided, but it requires tree plantings in the backyards of these properties.
So between the structure and the property line, your property line, there would have to be some trees and other landscaping that has to be done, shrubbery, trees, things of that nature. That's,
Okay,
yes, it's required to have a solid fence as well. Historically, that's 6.
Sorry, we're not trying to be rude, but we cannot pick up your voices on the, and this is transcribed, so we can't have these open discussions, and that's why we're trying to be clear about that, because we can't hear what you're saying.
the
And-
chair would give her 2 minutes so she can go back to the podium and ask
Do you have
another
other,
question.
I mean, don't.
Anything else you'd like to come up to the podium and ask?
Yeah, she said no.
Okay. Go up to the podium. State your name and address again so we know.
I'm Ruth Ryan, 1723 South Red Oaks. What would the height of the fence be that would be the buffer against the buildings? behind my
Historically,
house?
6 foot's maximum.
It's 6 minimum, 8 maximum.
So if it's a 2-story structure, then you would think an 8-foot fence would be more
No,
appropriate?
it's 6 minimum, 8 maximum.
Thank
Up
you.
to them. Okay. Any other questions for anybody?
I've got a question for the applicant, please. Kurt, would you mind? How do you see the parking on this? Are there garages, driveways? I mean,
Garages and driveways, yes.
okay, on the fourplexes that are in the center there, those are driveways that go back into the street there then?
Correct. They would go out to the fourplexes would back up to each other, and the driveways would go out towards the streets, yes.
2-car garages for each one, or is how much parking is there?
Single and double is what Clint's saying.
Okay, thank you.
Kirk, what height would those fourplexes be?
It'd be standard 2-story, so that's 25 feet, you said? Okay.
2-story, okay, thank you.
Cool.
Just a comment as far as ingress and egress out of there and the amount of traffic. Personal comment, for about 30 years, we lived in a subdivision that had 120 lots. And for the first 20 years, that really wasn't a problem. They ended up putting a stoplight in at some point, but and it was in a pretty heavily trafficked area. I suspect at some time they might want a traffic survey out there, but I don't think the density of what they're talking about is extraordinary.
Thank you for your comment. Anybody else? Mr. Foster.
If I could also put as a reminder here, we have to deal with the plat before so there will be a platting review of this property at some point in the future as well.
Thank you, Dave.
Well, I think there's a zoning issue, and that relates to making sure whatever we do on the landscape goes with this, because that's part of the ordinance. My question is, given that the Goebel piece is a public street and platted, what are going to be the limits of the buffering along the east side relative to this gentleman here for his property? Is he going to be out of luck to get any buffering clear up along the east side of Goebel?
Well, the ownership will go all the way to Harry Street. Will continue to be a strip of land. This really doesn't lend itself on this to show you distinctly. If you look at the little sketch that's attached to the staff report, Goebel Street right-of-way, there on the east side of the Goebel Street right-of-way, you still have a strip of land that goes till you get to the east side of this property. So there is a strip of land that right now is a part of the reserve in that plat that created Goble Street that is dedicated for essentially landscaping purposes. So when they come forward with the plans to actually build, the overall landscape plan that's got to be done as part of this project would envision, I presume, will stretch that all the way up to Harry Street.
Mr. Blick.
I just want to confirm staff. I asked a question behind the scenes. I just want to confirm the community speaker that was there, you did not find his PowerPoint presentation that was sent?
Did not receive it.
Okay,
Yeah,
thank
did
you.
not get it in
Just-
time.
Thank you.
Any other questions? Seeing none, we'll bring it back for action. Mr. Johnson, Bill Johnson.
Mr. Chairman, I'm going to approve per staff comments. I just want to say, if it was single family, it could be a two-story single family, and the neighbors next door would have the same situation where somebody looking down in their backyard. So I'm going to move to approve.
Second.
Have a second by Mr. Dew, I believe, first. And Mr. Foster has a comment.
Just some fine points on it. As we were looking at this, I'm relating this to the last case that we looked at. I frankly wish we were looking at a TF3 on this deal as opposed to multifamily on it. Now, however, I think there's some clarifications. One is, in the staff report, it references three-story multifamily buildings. Now, we've heard two-story, so I would think at minimum on the east side, the fourplexes there would be limited to the two-story on it. The second item is, I think there needs to be a clarification on this landscape buffer, given that we're looking at the more intense use, you know, and help me out here, Scott, if I'm remembering right, it's one tree every 40 feet.
That's
With
correct,
the
yes, sir.
fencing. Well, that doesn't cut it. I think there ought to be a tree every 20 feet along here to at least help soften the impact that there's going to be on all those single-family homes.
I'm getting confirmation here, this is a straight zone change, and I don't think we're allowed to make those type of.
In order to do the modifications you're talking about, we'd need to add a PO. There is not a site plan requirement. This isn't like some of the other communities where site plans come in with zone changes and you tie the zone change with a site plan. The only way you can do that is either with a conditional use, which isn't applicable here, or for you to require a protective overlay that would address those things.
Now, let me give you two cases. Case at Ridge Road, I think it was the Applebee's, and then we looked at the Quick Trip deal there. At the time of the zoning thing, we requested 1.5 times requirement of the landscape. We increased it, and that's what happened. And we even got into discussion of wall.
But you're
versus
talking
fencing.
about, you were talking about increasing the width of the buffer and other things that are not.
No.
Part of the.
Density of
No, I'm talking
plantings.
about a tree, one every 40 feet does nothing. So I'm suggesting that we would require a tree every 20 feet, double what the landscape ordinance requires. That's my suggestion.
Okay, which would require a protective overlay.
And
which is
the
what was done on the
two-story
property you
versus
was talking about.
three-story is simply just the height of the structures.
But the MF zoning, I don't see how you can put a restriction on the height limit without a PO, because it's base zoning. It allows 35 feet. I do not see how you can restrict it to 25 feet without using a PO.
So the proposed use here stated in the staff report says three-story.
For the audience, a PO is a protective overlay.
Well, and I'm assuming that's the information Dave had at the time that he.
Well, and that's permitted under the current regulations, so in the straight zoning. If you want to put those kind of restrictions, you'll have to amend the motion to include a PO that would address those restrictions.
Well, the landscape's a straightforward one. We can do that, obviously. Just
No.
double.
No.
Not without a protective overlay.
No, because the landscaping standards are established by ordinance. To put a higher standard on the property, you'll have to do it with the protective overlay.
I don't recall having protective overlays on
All of
those.
those have
Every
been
time.
POs.
Yeah, every time we've increased the landscaping requirement, it's been done either by, as Dale said, conditional use or by protective overlay.
Is the maker of the motion, and we'll take anything that Dave said?
Well, I don't think it fits in this case.
I mean, you could,
Now, let me ask you this, though, now, if the applicant agreed that it was two-story, can we agree to that?
Well, I mean, that's just his word. Without a protective overlay, there's no
Still won't
way
do
the
it.
city can
Okay.
enforce that height limit.
we can do a protective overlay, can't we?
Yes, I mean, you
So
could add
that's
that.
why I'm asking, is the maker of the motion willing to submit?
I guess I'd like them to make a substitute motion, and I decide whether I'd agree to it or not.
Of a comment. I think we've already established that there is a compatibility setback, so within 50 feet of the east property line, they can only go to 35 feet, which is the same as single family, right, Dave?
Yes.
And if you look at this site plan, that certainly doesn't, those properties are a lot closer than 50 feet. So I think you're going to by default end up with 35-foot height restriction, which is what it is in single family, which would allow a two-story building, but I don't believe
It
it
also allow
allows
a three-story building.
Well,
You,
I don't know about that. Yeah. But
be a
it's the
flat roof
same as
building.
within 50 feet, you'd have the same height restrictions as you do in a single family because of the compatibility setback.
Dave, do you want to try a substitute motion?
It'd be real simple, just move to approve with a protective overlay that would require along the east side 2-story as a maximum. And then the landscape buffer along the east side would have double the number of trees. Just simple as that.
We have a second to that?
I'll second it.
Second, Mr. Reed. Okay. Any more discussion?
That all fits within our rules and regulations.
Any more discussion? Seeing none, we'll vote on the protective overlay first. I mean, the motion, substitute motion first. All in favor?
Aye.
Opposed? Aye. 10-1. Passes. Anybody? There's no abstention, so 10-1. Thank you, Dave.
thank you.
Okay, now we're at the part of our agenda that we've all been waiting for. We get to hear from the, this was a great presentation. We heard this at Advanced Plans last week, and I can, having been there, I enjoyed it thoroughly. So let's have a presentation on the capital improvement plan. It was very good. Go ahead.
All right. Good afternoon, Mr. Chairman and Commissioners. I'm Mary Hunt, Principal Planner in the Planning Department. Each year, the CIP for the city is prepared for your review, and the CIP includes projects for the upcoming 10 years. So today, we have Mr. Mark Manning, our Budget Director for the City of Wichita, and he will present the CIP, after which we'll ask the Commission to determine if the program he's presented conforms to the goals of the Community Investment Plan or our comprehensive plan as required by Kansas law. As was mentioned just a moment ago, the Advanced Plans Committee did review the CIP and unanimously agreed that it did conform as required by law. So with that, I'll ask Mark to step up here and begin the presentation.
And we recommend it for approval, right?
Yes.
You have a clicker.
Let's see here.
How do you click? Just a mouse?
Yep.
Good afternoon. I'm Mark Manning, Department of Finance. Mary's introduction, if I'm really lucky, will be hopefully longer than my presentation. You have had the material with you from what I understand. I've already presented to about half of you at Advanced Plan, so I'll try to be as brief as possible and respectful of your time. That's not my PowerPoint.
It's ad lib.
Click on that.
There you
Oh,
go.
click on there, sorry. So here's some of the really high-level overview things from a policy standpoint you might want to be familiar with in our CIP. It's based on a mill levy of 7.5 mills, which is actually 1 mill less than what the city has levied for the last several years. Our city debt levels will rise, but they'll stay within what we consider to be appropriate levels. Local sales tax, as you know, was approved in 1986 in our community, and we've traditionally spent that mainly for Kellogg freeway improvements, but for other purposes. The CIP has a policy shift where we will probably spend a lot more of that on roads and a lot less in freeways into the future. And finally, this CIP was developed based on a prioritization model. We're trying to develop a model that involves empirical criteria in how we choose what projects go in the CIP and what don't, what do not. I've got a couple of pie charts. I'll go over them really fast. Takeaway is the CIP is about $1.8 billion. About 2/3 of it is water and sewer projects, or I'm sorry, about 1/3 is water and sewer projects, and arterials is about another third, and everything else is about another third. So this chart may not mean a whole lot to you, but the city council likes this. This shows our general obligation or property tax funded debt levels. The blue line there is the benchmark. We don't want to go over the blue line. And the takeaway on this slide is that the black line is below the blue line, which is to say we think our debt levels will be affordable within this CIP. I did have a question in advanced plans about our debt levels, so I wanted to include 2 brief slides to answer that question. I don't remember who asked me, but they asked me what our debt level. Oh, was it Joe? Okay, sorry. So this slide shows what our GO at large or property tax funded debt levels will be under this CIP. And the takeaway is, yes, they will increase, but over time then they'll mitigate, and at the end of the period in 2027, they'll be roughly about the same as where they were at the beginning of the period, roughly. So now I showed one more slide here, which is local sales tax. Again, we use this primarily to finance Kellogg improvements. Again, you'll see we expect it to accelerate in the near term as we finance the remainder of Kellogg through K96. But again, it'll moderate over time, and takeaway is it'll be relatively similar to what it's been for the last 6 or 7 years. Okay, here's the part that's probably the most interesting, hopefully, to you, and that is the criteria in which we decided what goes into the CIP. You'll notice our first criteria, alignment with the community investment plan. We take that very seriously. So we have this model. That is 20% of our empirical weighting, and we also want it to be consistent with other planning processes, neighborhood plans, or the aquatics master plan, a variety of different planning sources, but we want our CIP to be in alignment with those plans. Financial considerations is important, and we also have a variety of other considerations, but specifically to the community investment plan, we look, and we have your staff here, Mr. Knable, who's very graciously agrees to help us with this. He reviews every project, puts it into a model, and helps us determine whether we're in compliance or how we're into compliance with the strategic priorities, the overall spending priorities, and where our projects are in relation to the established central area. And I'll show you those statistics in a couple minutes, but just suffice to say here, those play a role in how we prioritize projects. Again, other planning processes, I'll kind of skip through that. Financial considerations, we like projects that leverage other funds. Other considerations, again, we like projects that have empirical thought basis behind them. Do they align with some of the decision support tools we have, or are we contractually or statutorily required to do them? So back to the community investments plan. Again, this is the chart Scott helps us prepare. You can see takeaway is we believe that about almost half of our projects are in the first priority, and the other half are spread in between the second and third. Although I will point out that the third priority, one reason that is so large is we do include in the CIP a lot of special assessment projects. Those are considered third priority, so that kind of inflates the third priority. But I'd also point out this is more in the first priority than what you would have seen a year ago had I been here. I think that was about 43% a year ago. So secondly, this chart Scott provides for us, which shows how we align to the plan priorities. And takeaway is over 70% is in the very high priority area based on the community investments plan. Again, that's actually slightly higher than what it was in the last CIP. So finally, you've had the CIP. I'm sure you've noticed all this. I'll go through these really fast. We have about 93 million in for public safety projects. Residential street maintenance is very important. There's about 78 million in for that. Again, we'll complete Kellogg. West Street corridor from Kellogg to, I think, MacArthur is in the CIP. We've got some money aligned to downtown catalyst sites. Again, aquatics, master plan, West Bank improvements, I'm sure you're familiar with, and we also spend some money on our cultural facilities. Here's the remainder of our schedule. August 7th, there'll be a city council meeting, which will be a public hearing. This usually gets overshadowed with the operating budget, which will have public hearing at the same time, but there will be a public hearing on the CIP at that date. And we would expect city council to adopt this CIP on August 14th. And so with that, like I said, it is online. That's what it looks like. Be happy to answer any questions, and I appreciate your time today.
Any questions? Mr. Foster.
I'm really glad you put those slides together, because when I read the staff report, and I really applaud Scott here for this model of trying to understand and make a correlation, because it wasn't but a year, maybe before that as well, that the concept of linking up the CIP to the comprehensive plan actually was an outgrowth of that whole comprehensive planning effort. So I think that's very important. And so I think it's a good effort here. What was really confusing me, though, is when you read this staff report here, let me just read a couple of these to you. The proposed CIP allocates 60% of the funding in the arterials to the lowest priority of expanding the street system. Then you go on down and it says, however, the amount budgeted is insufficient to bring existing streets up. In effect, it was at odds with the comprehensive plan. And so after I got done reading this, I said, you know, I'm going to tally this up. And what I came up with is that 8 of the items are not in conformance with the plan. 2 are, you kind of got to figure them out, and there's only 3 that are actually in conformance. And that's of this whole laundry list and this comparison when you go through it for public safety, arts, and culture. And so the slides that you've shown here now paint a much better picture. And my initial reaction was, no, this is not syncing up. So I appreciate your slides to get me comfortable that this is in conformity.
Thank you, Dave. Thanks. Any questions? Yes, Mr. Richardson.
If we look ahead to replacement of a performing arts center, I assume that would be GO bonds, and that's going to blow that chart kind of out of the sky, is it not?
I guess I can tell you pragmatically this. The city would really struggle to have the capacity to issue GO bonds under our current revenue structure for a performing arts center. But yes, it most likely would be GO financed.
None of that's anticipated in what you've shown us today.
You are exactly correct. It is not.
Thank you.
Nor is expansion of the convention center. Mr. Foster.
On your very first slide there, it commented that from the 2018, a pullback of $1 million.
Yes, sir.
And my question is that what we're seeing as a result of the information from the newspaper, what I'm hearing on the radio, all these negative things about trying to find funding? Is that caused by that pullback of $1 million?
Let me answer you this way. The proposed budget that the manager has for the operating side increases general fund levy by $1 million. In other words, we're taking $1 million from the CIP and putting it into the general operating budget. General operating budget funds things like police officers.
Any other questions? Mr. Blick.
A question on say $1 million. What are we talking about $4 million or $5 million for Wichita?
Three and a half.
3.5
Yes,
for
sir.
$1 million.
Yep.
Any other questions? What's the motion that you need?
I think I just need you to find it in conformance with the community investments plan.
I'll move. Second.
Moved by Mr. Warren, seconded by Mr. Dool. Any discussion? Seeing none, all in favor? Aye. Opposed? Okay, 10-0.
Very much.
Thank you, Mark. Nice presentation. Now we have another item for the non-public agenda. You're going to present this?
Yes. Okay, I have Mark Elder here today to present the Project Area Plan 2 for Union Station. I'll let him present the project, but let you know that staff did find it in conformity with the comprehensive plan.
That was pretty easy, Matt.
Good afternoon. As Matt said, I am Mark Elder with the Economic Development. This is phase 2 for the Union Station redevelopment project. In 2014, the redevelopment district was established, and at that time, or shortly after, I think 2015, the first phase of that project plan was presented for conformity for the with the comprehensive plan. So this is phase 2. They're kind of just moving south as they redevelop that project. And so this one will primarily focus on the Express building and the terminal building. This map here displays the 3 phases. The one closest to Douglas, where the hash marks actually go along Douglas, was phase 1 over here. Phase 2 is right in the middle, what we're talking about now, and then there's a potential phase 3 as the project moves forward. This map shows a little bit better perspective of what we're talking about for the second project area for this. The redevelopment will include it's roughly about 77,000 square feet of redevelopment and up to about 30,000 square feet of like an additional level on the Express building, as well as redoing all of the infrastructure, parking, and surrounding area within that project area. Just a few renderings of what the redevelopment of the terminal or Express and terminal buildings will actually look like, as well as you can see that the addition of the additional pavers, the planters, and landscaping amenities to go along with that. For this project, I kind of mentioned it's the rehab of those 2 buildings, as well as the addition of that second floor in the Express building, repaving, parking, inclusion of the sidewalk and pavers, as well as the new planters and landscaping. I believe that's actually it. I tried to make it brief for this presentation. I'm happy to answer any questions. Yep.
So there's no additional parking shown in this, right?
There is no construction of like an additional parking structure, but they will be redoing the parkings there. And I believe I've got Justin Strelo here at the development. There is additional parking being constructed in the back. Is that correct, or is it just rehabbing? Yeah. So on that, this area up here, there is an addition to the parking the way they're redoing that, but it won't be a new parking structure. That would be in phase 3.
Questions? Bob?
Does this require any action on our part?
Correct. The TIF statute requires that the project be presented to the Planning Commission for finding that's consistent with the comprehensive plan.
Okay. So when the original plan was presented, it was 3 phases, and phase 1 is done, and it was anticipated that phase 2 and phase 3 would be done?
Correct. It was anticipated 2 phases, and then as this project evolved, it was divided into 3 phases, and so, but yes, as it develops, then a new project plan will be presented for that next phase.
All we are talking about is whether it's generally in compliance with the future plan, right? We're not making any statement on how it's to be financed.
Correct.
That's correct.
Questions? Mr. Blick?
Phase 2, does that incorporate the 3 or 4 existing tenants that are right there? Because I noticed it comes all the way out to the edge. Is that
it does not incorporate the ones on Douglas that were done in the phase 1? Are you asking about like this Grand Hotel, the Rock Island Freight, and
No, over there beside the train tracks, you have 3 those little pocket businesses. That
those were actually they're on the plaza. They were part of the phase 1. This just is kind of just the west there behind that is where the phase 2 incorporates.
Yeah, I was noticing there was like a little overlay, and so that's why I was trying to figure out if that was the phase 2 also or not.
Correct.
Any other questions? Matt, are you okay with this? Okay, ready for a motion?
Move to approve
Compliance.
in compliance with the comprehensive plan.
Rob?
I second that.
Rob seconded. Any discussion? Seeing none, all in favor? Aye. Opposed? Oh, Bill's back. 11-0.
Goes by. I just want to know if anybody else ever rode a train out of that train station besides me.
Okay, I'm ready for a motion about the discussion item we had earlier today. That Rob was gonna,
Oh,
I was going to make.
other,
have to make a motion on that? Is that how that works?
yes.
Okay. I move that we ask staff to look into, more into the zoning for the, what would we call it, the rehab centers? See what's.
Drug rehab center.
Rehab centers, yeah, just to see
What other communities are doing, and
exactly. And if there's anything that we can tweak in ours to make it better.
Mr. Blick seconded? Second. I had one down here, I'm sorry. You're too far away.
Discussion.
Discussion.
So, I know we've approved a number of group home zoning requests in the past, and it seems to me that we have approved a group home drug rehab in a residential area before.
Technically, a group home does not include substance abuse. A group home is a developmentally disabled person for developmentally disabled people. But
It is group residence, and you have approved conditional uses for group residences in residential zoning. That is an option.
the last
I
one
was
that was,
thinking one out west, and now that you mentioned that, I do believe that was for people that are
yes,
handicapped or challenged. It wasn't rehab.
substance abuse, the one that comes to mind was the one in College Hill or, yeah.
Okay, any more discussion? Seeing none, all in favor? Aye. Opposed?
Aye.
Mr. Warren, okay. 2, Mr. Johnson. So it's 9-2. Passes. And we are adjourned. This may be a record.